My lord, all three of us are standing, item number 42 and 43. My lord, government also has to file their affidavit. I also want to file an additional rejoinder, my lord.
45,
42 and 43, supplementary hearing.
42 and 43. It's for hearing. At this stage, you want to file it.
My lord, well, this is a holiday, then the matter may come on 13th of May. Well, I think this one did not. But of this matter, hearing also it will like 2 hours, with the involvement of nearly 4,000 to 5,000 rupees. If we lose the case, if Mr. Party wins. So it will take time. They think on the Tuesday on 13th of May.
Okay. Mr. Tony Patel and counsel for the petitioner and Mr. Withdrawal and
Seniority.
seniors CGC. Have both prayed to permit the parties to file affidavit in the matters. It's also submitted that the financial stakes in both the matters are high. It's accordingly the prayers allowed. The affidavits, if any to be exchanged, may be done within 8/5/2025. List on 13/5/2025. 13/5 you want, right? It should be completed by 8th of May.
My lord. My lord, I may be also given permission to file additional rejoinder.
We have given you 40 to 43. Yes.
I beg to mention item 41, my lord.
Yes.
My lord, I have instruction to withdraw the matter, my lord.
Both sides are represented. If there are one instruction, Mr. Upadhyay and counsel for the petitioner seeks to withdraw this petition. Prayer is allowed, the matter is dismissed from withdrawal. Okay, any interim order is there?
No, my lord. Oblige.
May I, Your Lordship? Your Lordship, I beg to mention item number 36 and 37. Here we have not filed our counter affidavit, so at least 3 weeks time may be given, Your Lordship.
It's a 23 matter. You've taken a lot of adjournments. What's the matter about? 36 and 37? Huh?
Compensation matter, Your Lordship.
Compensation. Okay, 37, 38, past separate orders. Which says are represented on the prayer made by the Kangul and government advocate. One last opportunity is granted to the state respondents to file their affidavit in opposition to the matter. Next slide is made clear that if no affidavit is filed by the next date of listing, notices of materials available on record. 36, 37.
4 weeks, Your Lordship, right?
Okay, list after 2 weeks. 2 weeks time?
Okay. 3 weeks, Your Lordship, at least.
Okay, 3 weeks.
Oblige, Your Lordship.
May I, Lordship? Lordship, I would like to mention item number 22, Lordships. For withdrawal, Lordship, my client don't want to pursue this matter, Lordships. On instruction, Lordship, may please to allow to withdraw this matter, Lordship.
What says the represented?
Item number 22, Lordship.
Upon instructions, Mr. G. Bam, learned counsel for the petitioner, seeks to withdraw this petition. Prayer is for withdrawal or not pressing?
Lordship?
You are not pressing or it is withdrawn?
Yes, Lordship, not pressing this
Not
matter.
withdrawn. No, it is instruction not to press this matter. So accordingly, this petition stands closed, having not been pressed. An interim order is there?
No, Lordship, there is no interim order.
Okay.
Much obliged.
My lord, I'm making a mention on behalf of Mr. P. Mohanta, item number 33, my lord. The bail hearing, my lord, I've been telephonically informed that he is not, he has some personal difficulties today, my lord. So he has prayed that let be listed immediately after the coming vacation, my lord.
Okay.
21 on 21.
On instructions from Mr.
P. Mohanta.
P. Mahtar and counsel for the petitioner. From Mr. D. Sokil and counsel pays for adjournment. Here is allowed. List after ensuing due vacation. Is the case diary available? APP is there?
I've inquired with the office, my lord. It was not available till now,
Okay.
as of now.
The library shall produce the case diary by then. Okay.
There was an interim, yeah, my lord, interim protection was.
Interim bail granted and list and suspended till the next date of listing.
Obliged.
Lordship, I beg to mention item number 27, Lordship.
27.
27, Lordship. Petitioners doesn't want to pursue the further case here. Instruct me to withdraw the case here. I'm for the petitioner, Lordship.
Which is represented. The order will be in 27. Upon instructions, Mr.
Takar Bagang, Lordship.
Takar Bagang, BAGANG. Learned counsel for the petitioner. Somewhere said the petitioner does not want to. You want to withdraw it?
Yes, Lordship.
His instructions from the petitioner to withdraw the petition. It is allowed the matter stands dismissed on withdrawal. There's a item 26 IA. So that in view of the order passed in connected WBC 16 AP of 2025 of this IA stands closed. Any interim order is there?
Yes, Lordship. Interim order.
Interim order is the main representation. Interim order passed in stands. Vacated. Yes.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 39, 39. Your Lordship, there is an instruction for withdrawal. So therefore, I may be allowed to withdraw. I'm for the petitioner, Your Lordship.
Okay. Same order. Your name?
In Kaku, Nabam Kaku.
Navam Kakun. KAKUN. Okay. Any interim order is operating?
Yes, it is there in interim order.
Interim order passed today stands vacated. Okay.
Deeply obliged, Your Lordship.
Lordship. Lordship, I beg to mention item number 12, 13, and 14. 40. 12, 13, and 14. Lordship, these are connected matters, Lordship. We are praying for adjournment for today, Lordship.
12,
As the
13 and
12,
14.
13, and 40. The conducting
14,
counsel.
14 is a CRP and for 12 and 13 are criminal petition.
Yes, Lordship.
Huh? 40.
40.
Pass separate orders. What is your prayer?
Adjournment, Lordship.
Okay.
The conducting counsel is out of this, Lordship.
Represented on the prayer made by learned counsel for the, you are for the petitioner. You are
I'm for the petitioner in item number 13 and respondent in 12 and 40.
Item number 14.
12, 13, and 40.
No, in 13 you are petitioner.
Yes, Lordship.
In 13, counsel for the petitioner. 12 and 14. 12 and 14 for the- Okay.
Lordship, the interim may continue in item number 13.
Interim order passed.
13.
This item 13 stands extended to the next day of the state. Okay, let's start the vacation.
After?
After vacation.
Lordship, I beg to mention item number 15, 15.
Yes.
Here, Lordship, we have filed IA for implement of necessary party for rejoinder. So, however, conducting counsel is not available today.
No, if it's the IA pending, we'll have to dispose of the IA. It can't be kept pending.
Right.
Whether the council is here or not. You wait for your turn, let the matter be solved.
Lordship, actually, applicant is unable to appear before this honorable
See,
court.
After filing of an application for impleading, we don't need the council's argument. We'll have to see whether these the parties or not.
Lordship, due to
Whatever be the
road
reason, we're
blockade
not,
is
IA is
unable
not
to-
adjourning. Whatever be the good reason, we're not adjourning an IA, when it is only for impleadment. We'll consider that. Let the matter reach, then you make a prayer. We are not adjourning. Whatever be the good reason, we are not adjourning. Prayer for adjournment, please make when the matter reaches.
Lordship, on that he will be available before this honorable court. So only for
Impleading
today's.
applications, we are not adjourning. Impleading adjournment, we are not adjourning. Please bear with us. Renew the prayer when the matter is called.
Item number 38, my lord. This is the last, my lord, the same matter on the last occasion, my lord. I apprise your lordships to take instruction from the client, my lord. My lord, as per the instruction, my lord, the matter become infructuous. I may be allowed to withdraw the matter.
Okay.
Item number
Both sides
38.
are presented upon instructions. Mr. M. Kato, the counsel of the petitioner, submitted that the matter has become infructuous. So accordingly, matters from dismissed, having been rendered infructuous. Any interim order is there?
No, my lord.
Okay.
Develop.
Your Lordship, may I submit?
Yes.
Your Lordship, one counsel paid for adjournment for item number 12, 13, and 40, 40.
Yes.
Your Lordship, I am the petitioner in item number 12. Without informing me, they are praying for adjournment, my lord. They have not informed
made
me
the-
that they want to adjournment today.
Okay.
It is my matter, my lord.
Okay. Who made the prayer in item 12? Okay, we'll call the matter. Okay.
My lord.
Who is the counsel in item 12?
Your Lordship, in item number 12, Mr. G. Kalo.
No, you
G.
can't make a
Kalo.
prayer without informing others. You did not take consent in item 12. Your prayer is refused. We'll take up all the matters.
I was asked to seek adjournment.
The counsel is here. He is saying that consent is not taken.
All right.
Nobody informed me, my lord.
Okay, we'll take up the matter.
Okay.
My lord, oblige.
Like.
Yes, item 1.
Yes, my lord, this is previous bail application in connection with filing case number 08 of 2025.
Just a moment.
Lord, what happened? There was a long pending land dispute between two parties. However, on that 26/3/2025,
We'll call for the case diary. Allegations are attempt to murder. We'll call for the case diary.
my lord, in same case, 6 co-accused has been granted interim bail by this honorable court.
Not without case diary. Attempt to murder we can't give.
My lord, here, my lord, the applicant is innocent. My lord, the incident was occurred at Niomi at Kradat district. But applicant was at that day, the applicant was residing at Itanagar. My lord, I have annexed the CCTV footage of the applicant. He was attending family meeting at Itanagar, my lord. My lord, I have annexed the,
Where is?
my lord, at page number 20. Type copy at
20?
page 20.
20.
Yes, my lord.
We will see the issue of alibi. There are 6 persons who are said to be grievously injured.
Yes, yeah, my lord,
Then
allegation,
whether you were there or
allegations-
there is a issue relating to alibi.
my lord, allegation is very serious. However, the applicant was not involved in this case. He is
We
totally
don't know.
innocent.
We don't know. We are not accusing you of anything, but we'll have to see the CD.
My lord, till that, I may be,
I'm sorry. Not when it's.
my lord, since the other co-accused has been already granted interim bail.
We're sorry.
My lord, on same ground,
Parity is not permissible.
my lord, and next that is fixed on 9.
We'll fix the same day.
Yes, my lord, till that, my lord, I
No,
may,
no,
my lord.
I'm sorry. It is submitted that similar letters are posted on 9/4/2024. To get the case study produced on the said day, list on 9/4/2024.
Yes. Like, 1 to 4 lordship, 1 to
Huh?
4 similar.
1 to 4 all similar.
Like,
Will issue notice provided to compromise the matter.
yes, yes.
Will issue notice, it's
No.
an amenity case,
And
what you call
for the
activity
lordship,
case.
scan copy of the trial court record because this is
Okay.
pending before the.
Your name,
May I be please, your lordship?
your name,
T Tabing.
Mr. T. Tabing,
Yes, your lordship.
TABENG. Learned counsel. Heard Mr. T. Tabing, learned counsel was a petitioner. So it is the petitioners. That is submitted that in matter relating to.
Your lordship, this is a joint petition for quashing of FIR that.
We'll take it as a last matter in the day when you want to argue.
Pardon, your
If you want to argue, we'll take up as a last matter in the day.
Oh, okay.
Last matter. Yes.
Like lordship.
You see, be always in the courtroom, be cautious of what is happening. 1 year should always be with the judge. That is why I learned when we were in the 18 years of my practice. I put a question to the APP. I was allowing it. I was issuing a notice, but you stopped us. You wanted to argue. Now you'll have to wait for till the last item. Always be attentive. Always be attentive.
Your lordship.
You must learn the
I
lesson.
humble-
You must learn the lesson the hard way. We were
My
allowing,
sincere
we were
apologies,
issuing a
Your
notice
Lordship.
and staying it. But you
My-
wanted to argue.
My sincere apologies.
It's okay, we'll take it up last
Notice
matter.
notice may be issued.
But we'll have to make you wait for some time, then you'll realize. Your attention should always be there. This is the let this be a first lesson.
Yes, your
Nothing against you, but you must always be attentive.
yes. Your Lordship.
We'll take it up. Okay, when I resume at 12 o'clock after the break, we'll take it up then. Okay. This item 6. Yes.
Lordship. Petitioner is filed a RTI, Lordship. PIO is refused.
You can't get this. Your petition has no merit.
Lordship.
You see, you have filed an election petition.
Yes,
correct.
yes, correct, Your Worship.
In election petition, you can't have RTI and then get documents. You must read the Representation of the People's Act, the manner in which the trial should go on.
Why I'm coming, Your Worship? Because I have taken a plea on the election petition that.
Whatever plea you take, in
Yes,
an election petition, you must know how to bring evidence.
yes.
By RTI, you can't get evidence.
Lordship, as per Rule 93 of the Conduct of Election Rule, Rule 93, Lordship, there is a provision that the documents can be provided by the order of the competent court, Your Worship.
By order of the competent court.
Yes, Lordship.
Is RTI authorities competent court?
No, Lordship.
Then this
That's-
answers your query.
That's why the Lordship before this honorable
No,
court.
no, no, no. In election petition, we are not entertaining a writ for getting documents. You must know how to run a trial in a election petition. I'm sorry. Conduct of election has got nothing to do with the election petition filed under section 81. It's got nothing to do with that.
Because Lordship, we need the documents because we have taken a plea on the election petition that this was the irregularities, Lordship. Because if that is honorable
You-
court
you
is
see,
direct the PIO.
You see,
to
you may
furnish-
have taken a good ground. But to support this ground, you can't have a document called by way of an RTI. An RTI document in an election petition cannot be proved. Because a document has to be proved by the author or by the custodian of the document. If you're calling something from the election office, it will be the authorities will come and exhibit it. If you want to call the ballot papers, it will be the election office who will bring it and then those has to be exhibited. There's a manner in proving. To RTI, at least I am not aware, subject to what you say, at least we have not got any precedent of an election petition being proved by way of an RTI document.
Because your Lordship, the PIO, who is the returning officer, Lordship, he has
can't give it by RTI.
verbally communicated to the
He
petitioner.
can't give it by RTI.
Yes, who is the election petitioner in this.
He can't give it by RTI.
So they were supposed to dispose the documents relating to the election, Lordship.
But then you'll have to make an
No,
application,
yeah, that's-
appropriate
that's-
application in an election case.
That's why we are bound to come by filing a writ petition
It can't be.
because the state.
It can't be. We'll give you a simple example. Now, please envisage a trial of a defamation case. Somebody has made imputations against you, which is printed in the newspaper. Correct? Now, if you have to call anything from the newspaper office under the newspaper, what do you call, I forgot the Press Council Act. The requirement is that the documents are to be preserved by a newspaper for 6 months. And they are not bound by an RTI to divulge it to you. So you must go to court and make an appropriate application to have the documents saved and not to be destroyed. For example, ballot paper. The custodian of a ballot paper by RTI cannot give it to you. You will find a series of judgments which say a very recent judgment against the order of this court by the Supreme Court. What, when, how, where? These are the questions which you will have to prove. And for that, you are permitted to call for the records from an appropriate authority. Please take, we are waiting for some time, you take instructions, I think there are a few councils who will be able to tell you. Be prepared and then make your submissions again, we'll take it up after some time. After the election laws,
My lord, as my lord, Rule 93 prohibits these documents to be supplied, my lord, by any forum, my lord, except the competent court. Competent court is, my lord, has admittedly, my lord, he has said that he has filed an election petition, my lord.
he's a young lawyer, let him take,
My lord.
go through the relevant law and take us,
I will provide
They
the
must give
judgment,
they
judgment.
must be given an opportunity.
Yeah, my lord, definitely, my lord.
I may not give him same opportunity, but
My lord.
young lawyer is standing up, let him have an opportunity.
Right.
At 2 o'clock, be prepared. Last. Yes, item 7. Yes.
My lord,
We
revoke.
Your name?
Odugo.
Mr. Odu, I heard Mr. Odu counsel for the petitioner. Next one. Saving non-payment of contractual bills. The present petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Mr. L. Parmel, learned counsel for the standing counsel for the Power Department, representing all the respondents, accepts notice for all the respondents. You don't say respondent. Can you do that? So L. Parmel and standing counsel for the Power Department accepts notice for all the respondents. First, requisite extra copies of the petition be provided to him in the course of the day. Next, the pendency of this writ petition shall not be a bar for the, who is the competent authority? Who is the one who will pass orders for
my lord.
release?
Respondent note 7.
Okay. For respondents, including respondent number 7, to examine the claim of the petitioner and to release payment if found due. Next, for the learned counsel for the petitioner. The petitioner is at liberty to produce a certified copy of this order before the respondent number 7 to bring the order to the notice of the said authority. List after 4 weeks. Item 8. Oh, you are also there?
One
Yes, I am going to additional Advocate General for respondent 1.
1 and 3.
1 and
And 3.
3. Okay.
Item number 8.
Lord, item 8, I am Naveen Kumar, I am appearing through VC, Lord. May I please your lordship?
Yes.
Am I audible, my lord?
Yes.
Lord, in this case, I am challenging one of the proviso to add it to section 10A2B.
Oh, if you are challenging the proviso, then it
Yes.
has to come to a division bench.
Yes, that's why I thought I should be fair to the court, my lord, because this goes to DB.
Okay. Your name?
Naveen Kumar, N-A-V-E-E-N, Naveen Kumar.
Mr. N. Kumar, learned counsel for the petitioner, and Mr. S. Tapin, senior government advocate are present. Next one was the
1 to 3.
provisions of
Lord,
challenge the
my-
provision of what? Provision of?
Provisos added to section 10A2B. My lord, my prayer
Proviso-
number 9.
Proviso to section 10, capital A, within brackets, numerical 2, within bracket small b of the mines and minerals, within bracket, development and addition, bracket was act, 1957. Has been assailed, lists the matter before the division bench.
My lord is giving any date, not?
No, it will come because I can't give a date for the division bench. But division bench
No
is there from tomorrow, it will come.
Deeply obliged, deeply grateful.
May I please, your lordship? Your lordship, we have filed our affidavit in reply today, your lordship. I'm the petitioner, your lordship.
We'll have to file an interlocutory application to allow the acceptance of the affidavit. Last time by order dated 28 January, that was refused. Your affidavit cannot be kept on record.
Lordship, but on the last occasion, the conducting counsel for this case, Mr. N. Pada, has prayed for filing affidavit in reply, your lordship, on the last occasion, just before.
Look at this order, 28 January.
Your lordship, on 2/4/2025, your lordship, the conducting counsel has prayed for filing.
It was due to inadvertence, maybe we are not looked into the previous order. This order has to be recalled. If file an application, will recall.
Yes, your lordship.
Your name?
A. Talom.
Council submitted that. Pursuant to order dated 2/4/2025, from an affidavit in opposition has been, affidavit in reply has been filed on behalf of the petitioner today. Next paragraph. We take note of the, this is Mr. Why the government advocate is present. Next paragraph. Take note of the previous order dated 28 January 2025, whereby the prayer to file rejoinder affidavit was refused. Stop. The order dated 2/4/2025 was passed without taking note of the previous order dated 28 January 2025. Next paragraph. Therefore, the affidavits for filing cannot be accepted. Stop. However, the learned counsel for the petitioner is granted, however, the petitioner is granted liberty to file an interlocutory application for recalling of the order dated 28 January 2025. This is the matter as and when the said application is filed.
Mobilizations.
Lordship,
Yes.
Lordship, I'm sorry for the inconvenience and item number 6, Lordship. I may be withdraw.
Item 6. We will permit you to take appropriate steps in the election petition.
Yes,
About the
Lordship.
records.
Obliged, Lord. That will be.
Item 6. Mr.
Takar Bagang, Lordship.
T. Bagong, B-A-G-O-N-G.
Takar Bagang.
B-A-G.
Lordship.
Okay. Land counsel for the petitioner. Also with Mr. R. Sekiel and standing counsel for the
1 and 2, madam.
respondent numbers 1 and 7, as well as Ms. T. Bangu, the government advocate appearing for the respondent numbers 3, 4, Next one. In brief, the case of the petitioner is that he is the petitioner in in an election petition. Where is the number?
01, Lordship, 01/2024.
Where do you find that number?
Election petition. Lordship.
Okay, election petition number 1 of 2024, which is pending before this court. Okay. It is submitted that in order to establish his case, the petitioner had made an RTI application on 6/6/2024 before the returning officer 9 Chayang CHAYANG Tajo TAJO ST Assembly Constituency. The description of which is mentioned in paragraph 3 of the writ petition. First one. It is submitted that subsequent RTI application was filed on 19/6/2024 before the election officer, East Kameng District, SEPA. Requesting for providing in the document which is referred in paragraph 4 of this petition. However, the second application, which was filed on 19/6/2024, was rejected by a reply dated 5/7/2024. What about the first application? What has happened thereafter? In respect of first application, you don't say anything.
Yes, board application were rejected on the same grounds.
Okay, but you don't made statement in your petition. There is the statement in your petition.
Which is on annexure 7, page number 32, Lordship.
Page number 32.
Yes. This is a reply, Lordship.
Something is wrong. Something appears to be wrong. Your sequence is not there. Paragraph 3, you refer to a RTI application. Where is the reference to the reply in your pleadings?
Lordship, on the page number 32, on the last second paragraph, the documents
You see,
request.
this is not a reply to that. This is a reply with reference to
Yes, what happened?
letter of CEOs dated 12 September 2024.
Yes,
In last paragraph, it only says that your serial number 4 was furnished to you.
this is a reply or
But 18/6/2024, this letter is there. Where is that letter? You see,
What-
you are given some part of the information.
no,
Where is
Your
that?
Worship, what happened after the non-furnishing of the information, Lordship, the first appeal was filed before the first appellate authority, Lordship, which is on the page number 30, Lordship. This Annexure 5, Lordship. Under section 19 clause of the RTA Act 2005, Lordship. After that, the first appellate authority has forwarded the application to the PIO, Lordship. So subsequently, page number 32, which is the reply of the PIO in regard to the application forwarded by the first appellate authority, Lordship.
I will not be able to follow. You see, you are showing us a document. This Annexure 2 is application dated 6/6/24. Now you say that you have filed a reply, appeal. You are showing us page 30.
Yes.
In page 30, you don't say about this RTA application date. It's not mentioned. 6/6/24 date is not mentioned. Then you say last paragraph 5, last date of filing an appeal, 27/5 and 6/6, 3/6/66, you have already filed an appeal. So there's a link is missing.
Lordship, on the last, the documents requested and serial number 4 has been furnished to you on 18/6/2024 as per
No,
your.
you are showing us page 30 page.
No.
You are showing us page 30 that this is an appeal. This shows that this is an appeal arising out of Annexure 2.
Yes, Lordship. Annexure 5, page number 30 is the appeal, Lordship. It is an appeal application before the first appellate authority.
We are reading page 30 and asking you in this appeal, please show us that this appeal is against RTI application dated 6/6/24. Annexure 2. Sequence is missing. Just say.
Lordship, on the serial number 4 or page number 30, Lordship.
Appeal against the order passed.
Yes, reply for the information sought at serial number 9 of the Annexure A. It is received at letter so and so dated 5 July 2024.
Where is the reference to 5 July in your pleadings?
Yes, which is in favor of the RTA.
No oral information. Either there has a document, there is no document at all. You can't supplement statement in the repetition by an oral statement. Yes, sir. Let's just say, be that as it may, on a perusal of the writ petition, the petitioner is not found to have annexed all the documents. Because in respect of RTA application number 6/6/2024, the reply received is not annexed. Although the petitioner is referring to Annexure 5 of the writ petition as an appeal. So, but in the said appeal, there is no reference found to the RTI application dated 6/6/2024. So, in the absence of seriatim of the absence of the documents in seriatim, The court is disinclined to refer to the documents appended to this writ petition. Next paragraph, be that as in the conduct of an election petition, it would only be the jurisdiction of the competent court having jurisdiction to take up election matters, to pass appropriate orders to call for the relevant records. So there are several documents which cannot be parted with. Several documents under elections conducted under the Representation of the People's Act 1951, which cannot be parted with in form of an RTI application. Next, nonetheless, the jurisdictional court taking up election petition is not powerless to call for any record which is deemed to be relevant on being so satisfied with regard to its requirement in the election petition. Next paragraph. In view of the said legal position, the learned counsel for the petitioner pays to allow him to withdraw this writ petition and to take appropriate steps in connection with election petition number 1 of 2024. Next paragraph. The learned government advocate as well as the learned standing counsel for the respondent number 2 and you're for 2. 1 and 2. For 1 and 2. I have no objection to the prayers so made. Next, according to this, the prayer stands allowed, the matter stands closed on withdrawal. It debated the petitioner to take such steps in the election petition, as the petitioner will be so advised. Yes.
Yes, my lord. My lord, here the respondent number 2, 3 and till 5, my lord.
Affidavit in opposition, Mr. Dolo, is not been filed.
No, it
No,
has been
I've
filed.
already
my lord.
filed it. I think Mr. Kato is supposed to file for 1 to 5. I am for the 6 and 7. That has been filed.
Is filed, okay.
Another time and again, we are meeting to the officer concern of the partnership.
Pardon me?
Another time and again, we are intimating to the officer concern for partnerships, the parawise comment. So, so far I haven't received the parawise comment. So this is the since method is directly connected to this respondent. May I pray that some more time may be granted. So it's
No, if they are not giving it to you, they don't give it to you.
Malad.
You see, we are in the eastern part of India.
This is the letter we have intimated to the Malad. And even Malad officer personally has come and a copy of the writ petition. Thereafter, they are not returning back. They are supposed to rebut. Affidavit of this respondent 1 to 4, 1 to 5 is the requirement. Importance.
Mr. Dole, with this reference made, subject, he will never get an instruction. Look, you show Mr. Dole the letter.
No, in the meantime, my lord, I am suffering, my lord.
Yes.
My land has been encroached upon.
This subject says, forwarding of the draft affidavit in opposition in hard copy and professional bills. He has added a wrong word here.
In fact, we have sent the copy.
We understand, but you see, they won't reply to you because you have added a wrong word. Now what to do?
So at least some more time granted so that I can.
No, because then we'll ask your, the authorities, the head of the authority to come here and stay with you unless they give the entire instructions. We call the Director General, Government of India, Ministry of Home Affairs to your office.
Malad, respondent number 5, 4 and 5, Malad.
No, unless when 2 will come, he will not come alone. The Director General will travel with few people. So he'll bring all the records.
Malad, respondent number 4 and 5 is the Malad responsible officer.
The others are not interested. Director General will be interested. We call the Director General. Unless your Director General comes, he is not giving you instructions.
Malad, in that case,
And
Malad,
because
somehow.
we'll fix it that if the Director General also doesn't come and give you instructions, then the Justice Simabal will give 1 lakh rupees to the petitioner as cost of adjournment. They will make sure that you give the date when you want him to be in your office. We'll ensure that he comes.
Malad,
Give the date to attend your office.
13th of May. 13th of May, Malad.
13th of May, he'll attend your office and you'll file the affidavit by 15th.
No.
Okay, 30 time I'm going to give
30.
No. What I'm telling you, you fix around the month of April somewhere, this date to appear before you, then let the matter come on 30th.
Yes, on 30th.
No.
We don't want his presence in the court. We want presence of these authorities in your office.
30th April. Is your April. But he's saying the officer will come to his office on 30th of April.
30.
Then the matter will be listed same as for my request, 13th of May.
13th of May.
Yes, maybe listed, and prior to that, on 30th of April, officer will be
We'll attend your office with all the records.
Malad.
Mr. O. Parad, learned counsel for the petitioners is present. And he submits that despite this petition being filed on 6/12/2021, the respondent numbers 1 to 5 have not filed their affidavit in opposition. Next part. On a query of the court, Mr. M. Katul and DSGI has submitted that on 4/3/2025, he has drafted the affidavit in opposition and has sent the same to one Sri Chote Lal, CHHOTE, Chote Lal, Deputy Commandant of the Adjutant, ADJUTNT, 30 Battalion. Battalion is BN, capital B, small n, SSB, Dhiran. But in receipt of the signed copy of, no, but he has not received he received back the draft affidavit, and therefore, and moreover, the concerned deponent has also not come to swear the affidavit and to file the same. Next part. Mr. Y. Duloy and
Seniority.
Senior PTC appearing for respondent numbers 6 and 7
6 and
has
7.
submitted that an affidavit in opposition by the said respondents have already been filed. Ms. G. Ate, learned additional senior government advocate, has submitted that on behalf of respondent numbers 8 and 9.
9 and 10.
So 9 and 10. Okay, 9 and 10, the state has already filed an affidavit in opposition. Next para. In brief, the case of the petitioners is that in the year 1965, the armed forces had occupied land of many private individuals. On temporary basis. And thereafter, the Indian Army had vacated the land of the petitioners in between 1985 to 1990. And thereafter, the Shasastra Seema Bal had occupied the land without consent of the petitioners. So it is also projected that gradually the Shasastra Seema Bal had encroached further land petitioners. So it is projected that the Shasastra Seema Bal are not vacating the land. And neither they are paying any rent or have undertaken the process of acquiring the land. And accordingly, the present petition has been filed under Article 226 of the Constitution of India for a direction upon the respondents to acquire the land. Mr. Para,
My lord,
this is a read we can't allow. Good direction cannot be there to acquire the land. You can always make a prayer to vacate the land.
no, my lord, since they are using it illegally, my lord. No, my lord,
Still the direction to acquire land cannot be issued.
let them pay compensation, my lord. Let them acquire and give us the adequate compensation, my lord.
That's
All that
not
I
your
want
prayer.
is that, my lord, it's my land, my lord.
That's not your prayer. That's not your prayer. The second phase is to return the land.
Yes, my lord. In absence of the pay to the
According to my friend, the petitioner has made a prayer, had made prayer number 2, Roman 2, for a direction upon the respondent authorities to return the land of the petitioner. Next prayer. Insofar as the prayer for prayer number 1, Roman 1, for directing the respondents to acquire the land, the maintenance of such prayer would be considered when the matter is heard. Next paragraph. In the backdrop facts referred above, this court by an order dated 7/12/2021 had issued notice of motion returnable in 6 weeks. The matter was thereafter adjourned. On 20 occasions, the respondent numbers 1 to 5 have not filed their affidavit in opposition. Next paragraph, such circumstances. The court is inclined to issue a direction upon the respondent number 2, the Director General, Shasastra Seema Bal, within bracket respondent number 2, to report in the office of the Deputy Solicitor General of India at Itanagar, along with all such officers who are competent to provide appropriate instructions to the learned DSGI along with all relevant documents. And he would ensure his stay in Itanagar till such time the affidavit in opposition is Indian. To stop. The appearance of the respondent two with his concerned officials before the office of the Deputy Solicitor General of India, Itanagar is fixed on or before 30/4/2025. The affidavit in opposition shall be sworn and filed positively within 8/5/2025, and copy be served to the learned counsel for the petitioner as well as the learned senior CGC for the form number 6 and to the learned additional senior committee advocate for respond 1 and 10. Next is agreed to by all sides. List on 11/3/2025.
Isn't it the 13th, my lord, is convenient, 13th of May?
13/5. What I said
Yes,
something
yes.
else. Okay, 13/5. This is right. To start. If even despite if in spite of this order, an affidavit in opposition is not filed, the court will presume that the respondents number 1 to 5 have admitted the claim of the petitioner, and on the next date, by invoking the doctrine of non-traverse, allow the prayer number 2 of the petition. Next paragraph. List on 13/5/2025. Next paragraph, the learned DSGI shall transmit a downloaded copy of this order to the respondent number 2 to bring the order to the notice of the said authority.
Well, in similar situated condition, I played another case where this court has ordered either you pay the rent or vacate the premises.
This, what is the order?
This court has ordered, but
Because we can't give an order to land.
no, that cannot.
Cannot be.
Yes. Obliged.
You know this. Well, you have said it, then
Yes.
it's right. Give him that doctor, return that.
My lord, may I give your lordship indulgence? Item 41 has been withdrawn, my lord. My presence may be recorded.
You said both sides are represented. You want a name to be recorded?
Yes, my lord.
You Tell someone who has taken the dictation, item 41. Mr. BK Singh, counsel for the respondent number
For number 2, 3, 4, and 5.
2, 3, 4, and 5. Okay.
Obliged.
Item number 11.
My lord, in item number 11, my lord, I am appearing for respondent number 2 to 5 virtually, lord.
Yes. May it please your lordship. The petitioner is challenging the order, my lord, page 103, my lord. Yeah, my lord, what happened if so cause was issued to the petitioner, my lord? So cause notice, your lordship find it page 97.
97
is the so cause notice, my lord.
Yes.
And my lord, in this so cause notice, they have proposed a variation that your lordship will find is 101, my lord. Page number 101 is the variation they are proposing, my lord.
Yes. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation they are proposing, my lord. 101 is the variation Yes.
Now they are proposing to add an income of rupees 4 crore and odd, my lord. And in paragraph 3, my lord, they have sought our response in page 101, the last paragraph 3, my lord. They asked us to submit our response by 29/3/2022, my lord. Accordingly, my lord, at page 103, my lord,
Yes.
page 103, my lord, this is our acknowledgement. We have uploaded our response online, my lord. This assessment was done faceless, my lord. We have uploaded our detailed reply, my lord. The detailed reply starts from, my lord, page 103, my lord. Here we have all the particulars, work orders stating that we are not liable for payment of income tax since our income is exempted under section 1026 of the Income Tax Act, my lord. After submission of this, reply was submitted on 29/3/2022, my lord. And on the next day, my lord, order was passed. It will also will find at page 103, my lord. 103 is the order, my lord.
3, yes.
Sorry, my lord, it is the reply. I'm sorry.
103, you said
The
that is
reply.
the reply.
115, my lord. 115. It is the order, my lord.
102.
115. 115 is the detailed order, assessment order, my lord. Yes, my lord. And Lordship may kindly come to 118, my lord, page number 118, where the assessing officer has given a finding, my lord, that since we have not responded to the so-called notice, therefore he was left with no other option to pass the order, my lord. That your lordship will find at page 118, third paragraph, my lord. It starts from thus a series of
Just
notices,
a moment.
my lord.
Why there is a difference in the name, page 103 and page 115?
My lord. (103) and 115.
Name in 103 is CC Null Valley.
Perhaps might be some glitch in the online because PAN card number is same, my lord.
Where is it?
Lordship. It will also find the first column, PAN/10.
Yes.
ABRPW 9567A. The reason for passing the assessment order was that, my lord, there was no reply filed by the petitioner, but my reply was on record, my lord. It is at page 103. And that was not taken into consideration at all, my lord. Without considering my reply, the assessment order was passed, my lord.
Yes, what is the stand of the, in the affidavit in opposition?
In opposition, they have not categorically denied our, this stand that we have filed our reply, my lord.
Yes, Mr. Sedia.
Lordship, first of all, my lord, this order is in, my lord, appealable order. My lord, appeal lies under section 246.
No, but if it is perverse,
No,
why
my
we
lord,
can't
my lord,
entertain?
it was discussing details in the assessment order, my lord. Your lordship may see page 115, my lord. The assessment order.
Yes, in the same page you say that if the reply is not filed.
Lordship
Para
may
2.
see page number 116, my lord.
Page 115, para 2, you say the SSC failed to submit his reply.
My lord, in fact, lordship, opportunity was provided, my lord. He has filed a return in pursuant to, my lord, notice issued under section 148. That was considered, my lord. The details are not provided, my lord. He has not filed return earlier. He has not filed audited balance sheet, my lord. Nothing was
No,
there.
If somebody is exempted from income tax, why would
My
he
lord,
file a return?
My lord, yes, my lordship, return has to be filed, my lord. That exemption has to be claimed through filing a return. My lord, the exemption, my lord, under 1026, my lord, section 10 provides for, my lord, exemptions. There are various exemptions, my lord. And there are 50 subsections, my lord, for granting exemptions on various categories. One of the category is, my lord, subsection 26, which says, my lord, the community which belong to ST and accrued income from the source within the state of Arunachal Pradesh, he is exempted. My lord, to claim that, the assessee has to file return, my lord. What he is claiming, my lord, he is claiming immunity from the act, my lord. He is not immune, he is only exempted. And that exemption has to be claimed by filing a valid return. That was not filed. Thereafter, my lord, he was asked to furnish the.
But still, how do you reconcile page 103 with page 115 para 2?
My lord, even in para 2, my lord, thereafter it was written, my lord, may I read, lordship? The
Yes.
assessee failed to submit his reply in response to the query letter. In absence of any reply explanation, the return of the income of the assessee for the relevant assessment was examined on ITBA functioning in the e-portal. It is found that assessee has not filed his return of income for the assessment year 16-17. On the basis of profile of the assessee on the Insight portal 360-degree view, the assessee was paid credited rupees 4,75,20,000 by so and so. In view of the facts narrated above, the provisions of section 147 of the Income Tax Act and the assessing officer has reason to believe that the assessee was paid credited so and so by so and so under section 194C for contractual services rendered by the assessee, and the TDS of rupees 4,75,000 has also been deducted. Thereafter, my lord, see in the next paragraph. Therefore, statutory notice under section 148 of the Income Tax Act dated 30/3/21 was served on the assessee. Subsequently, notice under section 142 of the Income Tax Act dated 15/4/21 was served to the assessee through email, requiring the assessee to prepare a true and correct return of income in respect of which it is accessible, and to furnish the same as per provisions of the income tax rules. The assessee has not complied with the said notice. In response to the notice dated notice under section 148 of the Income Tax Act, the assessee has filed return of income for the assessment year 16-17 but not furnished any relevant required details. Thereafter, my lord, see page number 117, next page.
You say everything,
Lord.
but you don't say that the what do you call the reply to show cause notice was filed. You see, please come to page 97.
My lord.
97 is the show cause notice dated 27/3/2022.
Lordship.
Correct.
My lord.
In page 103, the date of this, what 6 or 7 column down,
My lord.
is 27 March 22. So
Lordship.
it responds to the same notice.
Lordship.
And then there is a reply. The statement that reply to show cause notice was filed is in paragraph 11 of the writ petition.
My lord.
Reply to paragraph 11 is at para 10 of your affidavit in opposition.
Lordship.
I would be happy if somebody files an affidavit before this court as a lawyer and says that I file an affidavit in opposition. If you don't consider it, I would not mind. I would be so happy. I file a writ petition. Please don't, in your order, don't refer to my writ petition.
No.
In the order, don't refer to my affidavit in opposition. I would be so happy. I am unnecessarily growing my beard.
Lordship, in fact, in his reply also, he has claiming.
No, whatever it is worth.
My lord.
If you consider it and reject it. But if you say that no reply filed, it perverse. I'm just saying in a lighter note.
Lordship.
Had I got a lot of time, I would have remained in my earlier after without.
That was not denied, my lord. That reply in our affidavit also, we have not denied that it was not filed, my
No,
lord.
we are more concerned with page 115.
My lord.
Failed to submit its reply. Now, there's something wrong in your portal. Your officer can't read what is in the portal. I think you'll have to see something is done to your portal so that your officers can read it.
In fact, my lord, the statutory requirement, my lord, which the petitioner needs to file, my lord, that audited balance sheet, lordship.
But that's okay. You could reject that and impose
My lord.
whatever you want to impose.
Lordship.
But if you don't consider, why you can't say that this is a perverse order?
My lord.
You pass a fresh order.
Lord, in the assessment order, my lord, otherwise, my lord, everything was discussed, my lord.
No, Mr. Jedi, I have no objection.
My lord.
If some lawyer filed it of that nature in my court, applicable for at least this bench, I would be so happy. If I don't have to read any reply or the repetition, I can assure you there will be no happier man than me.
Lord, to that extent, my lord, yes, my lord, it was written in the assessment order that he has not filed any reply, my lord.
That's perverse. Just like in the Kaun Parega Crorepati, we can give this to vote a friend. We have so many lawyers here. Let me ask everyone if they like, if I don't refer to the pleadings in my order, put it to vote. If you say so, otherwise not.
Lordship, that is something on record, lordship. So
We sit down that you pass a fresh order without, it is a faceless order.
Lordship.
You do it after considering this written reply.
My lord.
And there is also a facility for granting us video conferencing for personal hearing also, my lord.
No, that is a faceless, you can't do it.
It is in the scheme.
You
It is
file,
there.
you file a separate application, they
My
will
lord.
consider, but
My
not
lord.
this writ petition.
My lord.
Let Mr. R.S. Mishra and counsel for the petitioner. Also heard Mr. S. Setia and standing counsel for the income tax, representing all the respondents.
The time for the Union of India.
Oh, so for DJ, you are, okay, I'm sorry. For the
five.
respondent is 2 to 5.
Lordship.
Before that, you write Mr. M. Katul and DAGI appearing for respondent number 1.
Bye.
Next one. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the assessment order dated 30/3/2022 passed by the respondent number 2, my lord. Who is respondent number 2?
Respondent number 2 is my lord, Income Tax Officer / JCIT, Additional CIT, National Faceless Assessment Center, Delhi. Find it last page, my lord.
Passed by the competent authority the National Faceless Assessment Center, New Delhi, Department of Income Tax under the Ministry of Finance, Government of India. By which in the purported absence of any reply by the petitioner to the show cause notice dated
27/3/2022, my lord.
27/3/2022, the income of the petitioner was determined and the assessment was completed accordingly. Has been assailed. No, has challenged this one. It's not right now. The word is not required. Next paragraph. It may be mentioned that the authority which has passed the order cannot be ascertained as the order is purportedly made in the name of additional public joint public deputy public assistant commissioner of income tax public income tax officer. So therefore, in this order, the court has referred to the competent authority under the National Faceless Assessment Center. Next one. In view of the nature of order which is proposed to be passed, the pleadings and documents of the parties are not referred to. Next, it may be relevant to mention herein that the learned standing counsel for the income tax has raised a preliminary objection as to the maintainability of this writ petition on the ground that the impugned assessment order dated 30/3/2022 is an appealable order, and therefore it is submitted that the petitioner be delegated to file an appeal. First of all, the said issue raised would be dealt with in this order. Next paragraph. For the purpose of this order, It would suffice to mention that the petitioner was served with a show cause notice 27/3/2022 by referring to the petitioner's PAN number in respect of assessment year 2016-17 by which the petitioner was required to show cause as to why the proposed variation should be made. Amongst others, it was stated in the said show cause notice that a previous notice under section 142 within bracket 1 was issued on 21/10/2021 to submit relevant required details, which was not complied with. And accordingly, an opportunity was granted to the petitioner to furnish all the details along with evidence on or before 5/11/2021. In this said notice, it is projected that the petitioner had received contractual receipts of rupees 4,70, 20,493 however, though the petitioner is stated to have filed return of income, but not produced any details and evidence, and therefore the principles of best judgment assessment as provided under section 144 within bracket 1 was referred to. And the petitioner was put to notice that the payment received to the extent indicated above would be treated as the petitioner's income. Next problem. In this writ petition, the petitioner projects that on receipt of the said show cause notice dated 27/3/2022, on what is the date of submission?
29/3/2022.
On 29/3/2022, the reply of the petitioner where is the reference to reply? You have not filed any reply, you only filed documents.
No, my reply is there, page 1040 attachment, my lord, detailed reply is there.
No, where is the reference to 104 and page 103?
But this 104 along with documents are uploaded, my lord. It remarks column is there, my lord, and value of remarks. It's the words are not coming, my lord, but it is there.
Response submitted, you have said nil. You see, you have not filled up anything. Response submitted. You're not saying anything here. Page 103, one column is blank.
My lord. Below response submitted remarks is there, my lord. Below, just below response submitted, my lord, there is a column remarks, my lord. This entire thing is available in portal also, my lord.
The same continue. Referring to the said e-proceedings response acknowledgement, page 103 of the writ petition within bracket annexure G, which is an acknowledgement number 475288681290. It's at page 103, first line. There's a mention below response, below the column relating to response submitted under the nomenclature remarks, in inverted commas remarks. When reference is made to copy of the work order of Shimnit, 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 has been attached again, as earlier it was. No, this is not a reply.
But Lordship will
This
see.
is not a reply.
If Lordship they can check up, it is in the portal, my lord, is annexure G along with annex 104. Every document is in the portal available, my lord.
Then we can't allow this representation. It has to, Mr. Sethi will have to be given an opportunity of producing it.
Look, they can produce record because it is in portal. I have
Yes,
checked up, my lord.
because here you see in this para, you say that the copy of work order has been attached again, it was not scanned properly. Then you have a value of hash value of the remarks.
Yes, my lord. It is
Then below there is an attachment having a hash value attachment.
Yes,
So
ma'am.
there is only one document. Reference to two document is not there in this acknowledgement.
Lordship, my friend can verify record is available in the portal, my lord.
No, that's okay. But then we have to give an opportunity. We can't dispose of the writ petition.
Yes, ma'am. They have also not disputed this thing in the affidavit in opposition also.
You don't write all these things.
My lord.
Just say adjournment. So next para, the learning counsel for the petitioner has submitted that although in the impugned assessment order dated what is the date?
33/2022.
In para 2, in the second para of the first page, it is mentioned that the SCC has failed to submit his reply. But by referring to page 103 of the writ petition within bracket annexure G, it is submitted that the reply which is available from page 104 U2 108 was submitted. Next paragraph. As the e-proceedings response acknowledgement at page 103 of the writ petition within bracket annexure G does not clearly state as to whether any show cause reply was filed, comma. The court is inclined to tag the respondents number 2 to 5. Produce the record. To produce scan copy of the records of the acknowledgement at page 103 of the writ petition within bracket annexure G and the nature actions which was filed along with reference to the hash value, HASH, hash value. And the respondents will specifically provide instructions to their understanding also as to whether the reply at page 104, TO2, 108 of the petition was filed along with the said acknowledgement. Mr. Setia, how much time you need?
Lordship, may grant 3 weeks.
3 weeks. Okay. List on 30/4/2023. 30.
My lord.
Okay. 30/4/2025. It's okay for you,
My lord. There's an interim order, my lord.
Interim order passed today stands extended till the next date of the state. Take a short break and come back.
Lord, deeply obliged.
That is income tax return.
Tavin.
Tavin, then
Yes,
counsel
your
for the
lordship.
petitioner, as well as Ms. Kalagel and a deputy from the state. Next, Prakash. The
Your Honor, it is item number 12.
petitioner number 1. Where is the FIR?
Your lordship, FIR is annexure S20, your lordship, annexure 1.
The petitioner number 1 that filed an FIR dated 3/5/2023, alleging that the petitioner numbers 2, 3, and 4, while recklessly driving their motorcycle, had caused an accident which caused major damages to his vehicle. Accordingly, Itanagar PS case number 96/2023 under section 279/337/338/427 IPC was registered. However, the parties have entered into a settlement compromise by an agreement dated 17/3/2025. Certain conditions as mentioned therein. And accordingly, by filing this application under section 528 of BNSS, 2023, the complainant and the accused have jointly filed this, have jointly prayed for quashing of the FIR dated 3/5/2023. Gave rise to Itanagar PS case number 96 of 2023, corresponding to GR number 293 of 2023, wherein charge sheet number 80 of the 2024, dated 26/5/2024 has been filed. Next. Issue notice returnable on how much time?
2 weeks.
Return 4 weeks be issued. Where is the charge sheet? Where is the copy of charge sheet?
Charge sheet, this case is pending before CGM, learned CGM, UFIA, your lordship.
Charge sheet page 24, lordship.
Huh?
Page 24, charge sheet.
24.
Was 25.
Okay, next paragraph. The scan copies of the documents appended to the charge sheet. Number 80 of the 2024, dated 26/5/2024. A call for from the court of
Chief Judicial Magistrate.
Chief Judicial Magistrate.
Chief Judicial Magistrate, UPR lordship.
Is it pending there?
Yes, your lordship.
Charge sheet is submitted, dear lordship.
The signature, the certified copies were issued by the Sehistadar Civil JMFC. You see the page 28.
Yes, lordship, but in the page 24, lordship, it's forwarding the charge sheet.
That
to
is the charge sheet, but it goes to the magistrate.
Yes, lordship. They have received and they submitted before the CGM.
What you see, page 33, all these documents are by JMFC.
Okay.
All the next documents, 2 copies are issued by the JMFC. Where is the case pending? Where you missed it, the statement?
Your lordship, matter is the trial of this case yet to start. Matter is pending before GR branch CGM, Chief Judicial Magistrate.
Can't be. Once the charge sheet is filed, it will not go to GR branch. It can never go.
Matter is the trial of.
You find out, we'll take it up next day. Which court is pending, at least you should know that. On a query of the court, they just Ms. L. Aguilar and counsel, the petitioner is, sorry, APP is present. The learned counsel for the petitioner shall obtain information as to the court whether the trial of the connected case is pending. Stop. List Thursday, Wednesday. List on 9/4/2025. Find out where the case is pending. It can't go to GR once it is filed. If it goes to GR, then the CGM will have to be, he'll have to give information. Why it went to GR? Yes.
Lordship, in this case, charge sheet is filed. And
Charge sheet is filed, we understand that.
being the court, chief judicial magistrate,
If it is before the chief judicial magistrate or judicial magistrate, first class will not issue a certified copy.
court of committal proceeding has to be done. Whether this
Committal?
case, yes, committal
In an
is
accident
yet-
case?
yet- committal is yet to be done.
We are yet to learn many things. In an accident case, you want committal proceedings.
Because lordship,
You see, the more you submit, the more you expose yourself,
yes,
and you will confuse us. In which cases, just tell me preliminary things. In which case committal proceedings are drawn up?
we wanted to say, lordship, this,
Please tell us in which cases, which category of
documents
cases.
we have applied the documents and our documents has been furnished by the judicial
If
magistrate.
the case is pending in CGM, you will apply in judicial magistrate first class.
Generally, in procedure,
Don't tell us, don't tell us.
in practice, that is going on. Generally, case goes
It
to
can't
the
go
chief-
on.
chief
This
judicial
practice can't happen. Anybody who's,
record may be called for.
any learned counsel who appears in the trial courts? Please come forward. Please assist us. How do you get certified copies here in the chief judicial magistrate court?
In this instant case, just after listening, from chief judicial magistrate, there is a Serestagar. They apply through their means by filing application to get the certified copy of concerned particular case or particular order. And in this case, as per my understanding, I think this charge sheet and filed before this GR branch, and GR branch supposed to endorse that copy to chief judicial magistrate, and JMFC is working under CJM. So until unless that has been endorsed, that case will be not put up there. So
You're right.
yes,
You're right. You have sufficient experience. Thank you.
highly obliged.
Yes.
Then Lordship, when the next date, Lordship?
7, sorry, it will be 9th.
Record may be called for.
No, you're not calling for the records. You tell us. You can't say where the matter is pending and you want to issuance of notice. We don't do it. Yeah. We ask you where this is pending and you don't do it.
All right, Lordship.
You can't tell us. And you see, your young friend is knowing. He has real practice. That is wonderful to meet a lawyer who has trial court practice.
Item number 12 and 13.
Like I am appearing in item number 12 for petitioners.
Yes.
But in this matter, I have filed an IA for taking additional facts and documents from record. And on the last date of hearing, the counsel for SIT has taken time to file reply of this IA. Reply till today, reply has not been filed, my lord.
May I please, Lordship?
Yes.
Lordship, conducting counsel is not present before the court today, Lordship. He's out of station, Lordship. So therefore, I have been asked to seek adjournment for today, Lordship.
You should have taken consent. Without taking consent, you will just tell us whether you will appreciate if you stand in the court from morning till evening, and at the end of the evening you come to know that the other side has taken adjournment and went back
Lordship,
without consent.
I may tender my apology, Lordship.
No, you see, so far as I am there, I am inconsequential. It is for the healthy bar. It's not for the court. Satisfaction of the court is not there. It is satisfaction of the bar that you have at least informed your colleague before taking an adjournment. Neither your time nor the time of the learned counsel who is online would have been wasted. It should be a healthy practice to at least inform others.
Lordship.
Because you see, that's why this Itanagar bar is such a healthy bar. I really like it. So please maintain that what you call those parameters where you maintain that.
Lordship, actually, what has transpired today, Lordship, was I was by the conducting counsel, I was instructed to seek for adjournment today.
That's okay, but
Your Lordship,
please, you see, we are not. I'm not venting out my anger. Correct. What I'm trying to tell you that even if somebody asks you to do it, please make sure that you have the instructions that that the other side has been informed. Basic courtesy we require for a healthy bar. Please don't take it that I am sermoning. It's not my business to do that. What we are trying to say is that since there's an obsession counsel who's present all throughout, at least any member of the bar, he will feel very annoyed when in the later on when he finds that his matter was not called. Somebody took an adjournment without informing him. Only that much. The courtesy demands it. Had you had requested, he would not have denied that. But you'll have to take instructions and tell us by when he will be filing an objection, if any, or if he doesn't want to file it. Then we'll
Madam,
take it on the bar.
he did not pray, Madam, he did not pray for filing or reply, or SIT, counsel for SIT prayed for time to file reply, Madam. Counsel for
I think
SIT, Madam.
I think they have filed in IA, man. And I have received that IA through WhatsApp just 3 or 4 days back. So I won't be filing any reply to that effect, man. On merit,
You're
I'll
not filing a reply. Okay. And so far as you are concerned, please instructions.
Page
and come
for
back.
respondent number 2, Madam.
My lord, I've
Respondent
been
number
told that the conducting counsel is medically admitted, my lord.
No, we understand. You see, the grounds are okay. It's only the issue of taking a prior consent. Now, but somebody will have to tell us that the reply, if any, will be filed or not will be filed.
Madam, last day he did not pray for filing or reply.
No, that's okay. Now when the learned standing counsel for the SIT says that the lawyer is hospitalized.
Now,
then
so it's okay, Madam. I am just Madam praying for that.
No, it's okay. Then perhaps he can't give instructions if he's hospitalized.
Madam.
Okay. In this case, we condone that because he is hospitalized.
Lordship, I have one submission to make. I was instructed to seek prayer for continuation of the interim order.
That's okay, but the question is of reply. If he's filing a reply, then it's okay. If he's not filing a reply, that's the issue. Can you get instructions by 10th of April? Whether he's filing a reply or not?
All right. We will seek instructions.
Possible to get instructions by 10th?
By 10th. Okay, I will seek instructions.
Okay, rather what we do is, instead of keeping it on 10th, we are fixing it on 23rd.
23rd of April.
23rd of April, reply if any be filed by then. You get sufficient time. And otherwise, we proceed with the matter on the basis of the materials available on record, insofar as this IA is concerned. Correct?
No, sir.
Okay, then we save one date. Okay, your name is Mr.
E Paying.
Rohit Jagwani.
Huh?
Rohit Jagwani. ROHIT Rohit,
Oh, okay.
JAGWNI.
R. Jagwani, JGWNI, learned counsel who appears through, for the applicant who appears through video conferencing. Next, brother. Mr. I forgot the name.
J. Sring.
J.
Sring.
Learned standing counsel for the
Respondent.
SIC.
SIT.
SIT is present. First of Mr.
E Paying. E Paying.
T.
Paying.
E.
E Paying.
P-A-Y-E-N-G.
EDDIE
Okay. Learned counsel come upon instructions from the counsel for the respondent number 2 has prayed for adjournment on the ground that the learned counsel has been hospitalized. Next paragraph. The learned standing counsel for the SIT submits that in connection with this interlocutory application, he is instructed not to file any objection. Next paragraph. In view of the reasons assigned, the matter stands adjourned so as to enable the round number 2 to file affidavit in opposition, if any, to this interlocutory application, at least 1 day prior to the next date of listing, with copy thereof be emailed to the learned counsel for the petition. Next paragraph, list on 23/4/2025. Now, there would be a prayer, there will be an order in the item 13. All sides are represented. Is the connected interlocutory application is fixed on 23/4/2025. List this matter on the same date. Then what is this item? Criminal petition 212. What is this?
This is in this petition, I am appealing for respondent, and petitioner has challenged the order passed by the trial court where their interim application for maintenance has been rejected. So they have challenged that order. I am
Your
for
Honor,
respondent.
Your Lordship, in this item, we are the petitioner, Your Honor. In this item number 13/212, WPC 212, we are the petitioner, Lordship. And on the previous occasion, we were granted interim bail. This, in this connection with this case, I was praying for interim.
Now, is this interim payment of rupees 8,000 being paid, Mr. Jagwani?
Yes, my lord. But and actually, in the trial court, the wife has moved an application that this amount should be deducted from the pension of the petitioner. So they have filed the application in the trial court. That application is pending, my lord.
No. This court has passed an order that 8,000 rupees maintenance must be paid.
Yes.
Is
Yes, my lord.
it being paid?
Yes, it is continuously paying, my lord.
Okay. In this next item, criminal petition 212. You say that 13. Okay. The learned counsel for the petitioner prays for adjournment as the conducting counsel is hospitalized. Next, Mr. R. Jagwani, learned counsel for the respondent, appears through video conferencing. Next, prayer made by the made on behalf of the learned counsel for the petitioner for the matter stands adjourned today. Next, on a query of the court, the learned counsel for the respondent has submitted that in compliance to the order dated 22/11/2023, maintenance amount of rupees 8,000 is being regularly paid to the petitioner. Next paragraph. The interim order passed earlier stands extended to the next date of listing. Next paragraph, connected matters are listed on 23/4/2025. This matter on 23/4/2025.
Yeah, so there is one more matter, item number 40, item 40. It is also between the similar parties where I have challenged the proceeding of domestic violence.
40.
Yes, my lord. Same counsels are there, my lord. So my payer may kindly take this matter also. Last date, my lord, has been issued to the respondent wife, and their reply is pending, my lord.
Are you instructed to appear in the matter?
Yeah, so in the morning he was praying for adjournment. It means that he is aware of that order, my lord. He is aware of that case, my lord. He was praying for adjournment of this matter, my lord, item number 40.
Yes, Lordship.
You will appear.
Yes, I'm appearing, Lordship.
Oh, okay. R. Jagwani, the counsel of the petitioner, is present through video conferencing. Petitioners. Video conference. Next, brother. Say bank and counsel appears on behalf of Mr.
G. Talo, Galentalo. Galentalo.
G. Talo, the counsel, who is presently indisposed and hospitalized, and he has submitted that the said counsel will file his wakalatam in due course. So it is also submitted that it said learned counsel is appearing in the other connected matters. Next paragraph. On behalf of the learned counsel for the respondent, prayer for adjournment is made. Prayer is allowed. Responsibility, if any, in this criminal petition be filed at least 1 day prior to the next day with copy thereof, sent by email to the learned counsel for the petitioner. Next paragraph. The connected matters are listed on 23/4/2025. List this matter 23/4/2025.
Nice.
Your Lordship, in this matter, my humble payer, my name is not reflecting in the cause list in item number 40. So my lord, registry may kindly directed to reflect my name in the cause list.
Okay, the registry shall reflect the name of Mr. R. Jagwani as learned counsel for the petitioner, Mr. M. Ate, learned counsel, while listing the matter next. Okay.
All right, man.
Yes, Mr. Clerk.
Yeah, Malad, the short question involved in this civil revision petition is that there is a land dispute between the clan brothers, that is the petitioner and the respondent. Here, what had happened, Malad, in the meantime, there is a Gambura, Old Damin Panasian Gambura Welfare Association, Malad. Assuming the jurisdiction, Malad, of an appellate forum, Malad, that in terms of section 15 and subsequent amendment 2022 in the AP Civil Code, Milord. Now, when the matter is pending, Milord, in the primary village authority case, in that event has taken, assumed the jurisdiction so moto and proceeded with the trial. And then, Milord, pertinently, Milord, when I was flipping through the affidavit in opposition file, Milord, then an impugn order came to be passed, Milord. Another order came to be passed. Then thereafter, Milord, one Gambura, Milord, who purportedly attended the mail in Nisi, Milord, we call it Nyel or Mel, Milord. In Galo and Adi, it is Kaba and Kaba, Milord. So there, he has come out with an, to whom it may concern certificate, saying that there was no Nyel or Nyele held on 10/10/2024. So that is my stand, and I have filed my rejoinder this morning. You received the copy?
Just I received.
Yes.
Just received.
So therefore, when the last two occasions when the matter was listed, Milord, when that impugn purported inter village order came, Milord, then I realized that the purpose of filing the civil revision petition no more remains alive, because an order has rightly or wrongly been passed.
They have disowned the mail on 10/10.
Yes, Milord. So therefore, Milord, now that particular mail is in question, Milord, because one of the Gambura, Milord, who has, Milord will kindly have the additional rejoinder that I have filed to them.
This one?
Yes, Milord. Okay. Rejoinder this morning, which I have filed. Please,
So just a moment, whether
yeah, I just received.
You've got it.
Yes.
You have instructions in the matter?
Yes, Lordship.
Do you have instructions in the matter?
Yes, just I've gone through. So there's
Okay.
no issue. We can, that
You-
will not impact too much.
My Lord, kindly see page 95. We have to make it continuation, my Lord,
Yes.
in terms of, I do hereby state on affirm that on 10/10/24, no kabang bracket
Just before you read it,
my Lord.
page 95, correct? It's written in English and there's a thumb impression.
Well,
And
yes.
nobody has stated that this has been read over and explained.
My Lord, this is the concern Gambura, my Lord, has
No, we
given.
understand.
And my Lord, there is a video clip also which we will be furnishing, my Lord.
No.
Yes, my Lord, that normally in the criminal case, when the IO sends the challan, then they record the state 161. They said read over and accept it like that.
But just tell us, page 96 appears to be in local dialect.
Well, this is in the local dialect, and this is
But why,
translation.
this, what
This
you
is
call, in
translation.
95, there's an English translation, and again, there's a thumb impression. Why?
My Lord, this is in Nisi, my Lord.
Hmm?
Nisi dialect.
No, you see, page 96 is in dialect.
No, my Lord, my younger says this page 96 is the Nisi version,
You understand, but why this English translation is also having a thumb impression?
Yeah, but illiterate. The respected head Dambura.
But you see, I can't read this dialect at page 96. You may be more acquainted, but the last line, this English word, Gogunam, so-and-so, video recording. So therefore,
Milord, in Nisi, Milord.
Therefore, this appears that this page 96 and page 95 are two different documents. This is not an English translation.
No, Milord, this is not translation. Normally, Milord, the for video, there is no Nisi word, Milord. So therefore, with the passage of time.
I'm not an English or that.
Okay.
What I'm trying to understand is that page 96 is not the translation version of 96 is not 95.
No, Milord. 96 is a declaration made in English by one of the judges in English, and page 96 is a declaration made in Nisi, Milord.
But these two are different. That's what we are asking. You see, in this page 95, reference to video conference is not there. The video recording is not there. But in the Nishi language,
Milord, this is in Nisi language, Milord.
But it contains that video recording. Video recording is not there in English.
It is not there in English, Milord.
So that means it's not a correct translation. 95 is not a correct translation of 96.
Milord, may I just clarify?
Yes.
Page 95, Milord, is in the form of declaration. That is to whom it may concern purely in English. And for Milord, what happened for the easy understanding of the local dialect, Milord. So this is used in Nisi. This is purely Nisi, but few English words were put into.
No, that's okay. But video conference, video recording is not there in this English.
Tanya, can you just help me because it is in. I'll take his help. Although I can read it.
No, I can read this language, but English word caught my eyes. This video conference, the video recording is not there in this 95.
It is
anywhere.
occurring in which line, Milord? With great respect, Milord. Oh, so Gionam home, video recording come Mapajipane. Milord, that means whatever I have stated, I have also made a video recording and kept it.
But in English, it is not there.
English, that's why, Milord. What I made a humble submission was, Milord, the page 95 is a declaration made in the form of to whom it may concern in English, Milord. And here, this is a Nisi version. But one line in the last sentence, which has become a case point before my Lord, is that.
No, I'm just trying to understand. You see. No, see, I'm not doubting you, Mr.
My Lord.
It's a natural question when
obviously
when I'm reading it, if it's not massive, it's a natural question. This one.
I gratefully.
And second thing is, in page 95, what is stated is that he disowns that there was a mail on 10/10 and he withdraws himself. But this order of mail still remains.
My Lord, probably, I think my Lord is on the.
Because this order has to be annulled.
Because my Lord is invoking section 81 of the Evidence Act, presumption of correctness.
I'm not doing anything.
No, I am so sorry. I was thinking because if my memory is correct, Milord.
I'm just trying to ask you,
My Lord.
You see, if there's an order,
correct,
merely because, let us assume the worst. I'm giving very horrible examples. I'm giving one. Now let us assume that there's a division bench and the division bench passes an order. Then I come and say that, well, there was no consensus and I did not want to sign it. And therefore I withdraw myself from that order. Let us assume there was something like that.
My lord, my understanding to my lord's example is a question of question of dissent. Here it is bit, my lord, vice versa to it. Here, first 95 is an English version. Second is a declaration of the same fact, but my lord, one sentence
It's
of
okay,
English is.
we omit that for the time being. But you see, the essence of what is there, that he signed a document and now he's saying that I withdrawn. After signing, he becomes a frontis officio, he can't withdraw. There has to be a court order to annul that order. Author of, in the example which I gave.
Well, I respectfully agree because 2008 judgment. Can you find out that day I told you? Yes, I did. 2008, my lord, there is a judgment by the apex court which says even if an order is illegal, even void ab initio, it will have a force of law unless it is not put to challenge and cure to the judicial pronouncement. So therefore, my lord, I respectfully agree with my lord on this particular point. Rightly or the wrongly, a judge who was purportedly part of making adjudication of a lease, he comes and resides back. In that event, what would be the judicial solution? So judicial solution, my lord, first, since my lord, I am on the rejoinder. Secondly, this order must be put into challenge. And my lord, in that event, there is a contradictions of material. Once there is a contradictions, my lord, say for example, my lord, just newspaper reporting, my lord. So newspaper reporting, my lord, under section 78, my lord, it comes under the definition of the hearsay. So it do not have. So therefore, my lord, the consequences is the presumption of correctness of that report, my lord. That's section 81(2) of the Evidence Act, my lord. So therefore, my lord, if this presumption is to be done, in that even, my lord, to my respectful submission would be two things coming up, my lord. The first thing is there was a kava or no kava at all. One. Number two, if this order, my lord, if this order, my lord, can you find out? My lord, if this order, my lord, if one particular judge is resigning that he has not signed, then, my lord, section 3E of the AP Civil Code Act defines the customary code. So similarly, my lord, in the new BNS, my lord, BNSS, section 2, subsection 37, probably, my lord, the definition of the public servant is there. So in that even, a particular customary court judge is committing a contempt of the court itself. Since, my lord, the objective of the Contempt of the Court Act, my lord, if we read down objectively, the lower court does not have the power to exercise the contempt jurisdiction. In CPC, my lord is aware, only for violation of any injunction order under Order 39, Rule 2A, my lord. That possibility. My lord, we will come back at 2, my lord.
Okay.
Yes, I will come back at 2. The material. Fine. Thank you for I remember. No, that's. My compilation. Done, done, I have sent you that. You asked somebody. Yes, ma'am. I am extremely correct, ma'am. 2008, 7 SSC page 748. Irregular or erroneous or even
2008
legal order.
2008 7 SCC.
2008, 7 SSC page 748. The language is irregular or erroneous or even illegal order cannot be held to null and void ab initio. That is, it is reiterated in 2014, 7 SSC page 707.
2014.
7 SSC page 707. I was dealing one matter in Meghalaya High Court, Milord. So this I remember.
You have a good memory.
I am grateful, Milord.
You know, there is a judgment in the Supreme Court of India,
Correct.
which is well relied and referred. Many of you here may have referred it many times, the judgment, but all refer to the last part of the judgment. In the first paragraph of the judgment, there is something very unique.
Correct, Milord.
The judgment is of Ram and Shyam. I think Ram and Shyam, you must, many of you must have referred to.
Milord is reported in which year, Milord?
Ram and Shyam is in contract matters leading judgment. Now 85 3 SCC 267. You see, the uniqueness of this case is that
275, Milord.
85 3 SCC 267.
267.
The uniqueness of this decision is that on the day when the judgment was pronounced, a 2-line order was passed that we allow this writ petition. And it was delivered. The reasons were to come later, but that never came. One of the judges, honorable judges in the Supreme Court, recused himself. He said that I am not signing it. And therefore, Ram and Shyam is a division bench judgment authored by one judge. And this is a leading law. And this is, Ram and Shyam is being referred in, I think, not less than 1,000 cases.
Yes, that Rajasthan High Court Bar Association case dealing with the master of roster. In this, Milord, that I now recall, Milord, that judgment I argued before His Lordship, then Chief Justice, who is now sitting in the apex.
No, I was just referring to this because of your submission in that case. That there was a kebang, but one of the Gamburas, he recused himself.
Two of them.
Whoever means I have a judgment by Ram and Shyam where these situations were dealt with.
Well, I just during lunch break.
No, it's okay. Don't need to read it because that's the only point.
Correct.
It was a division bench order to dismiss it, but reasons did not come. So the learned single judge had authored the judgment, and it's a leading judgment in the. It was authored by Justice Desai.
Okay. Well, I had gone to Ram and Shyam. Paragraph 1. The author of the judgments are then Lordship Justice Desai and Justice Zahrul Islam, who is the father of our Nazrul Islam in Guwahati. So there what had happened is both of them has consented and delivered the operating portion in an open court. Then in para 2, my lord, Justice Islam leaves the court without signing it. So then Justice Desai concluded by saying, since the operating portion has been delivered by means of consent, so it will have a valid. So withdrawal.
That is why still it's a division bench judgment.
A division bench judgment. My lord. But here, my lord, my case is fact is bit distinguishable, my lord, because no kaba was held, no nyel or kabang was held. Judgments of this particular impugn order 10/10/24 signatures were obtained at the residence. So that I'll come, my lord, where precisely I'm coming to the fact of the case now, my lord. The fact, my lord, I precisely tried to confine in my synopsis, my lord. It is already, my lord, synopsis rate of the fact, my lord. I'll seek the kind indulgence of my lord to page 17 straight, the first mail order.
Page
17, 17.
17. Yes.
Now, my lord, finally, this land dispute between the two cousins of a same clan, my lord, was there's note in between Chakpu Tasap of Spring versus Chakpu Roy and Chakpu Tahik at lowest judiciary as per the Administration Justice Regulation Act 1948, Marianga Village on that date is, my lord, 17/4. My lord will kindly, I regret it is not, but I have mentioned here, my lord, it is not written in the index also, my lord. Kindly take down the note, my lord. 17/4/2023.
Yes.
Now, my lord, this meal in Niti, my lord, was held, but the decision remained inconclusive, my lord. My lord, kindly, I seek kind indulgence of my lord to paragraph 5 of my CRP, my lord. I have described this here, my lord.
Yes.
Page 6, my lord. That the petitioner state that in March 2023, respondent number 1 began claiming the Marenga Ringte 1, Sonu, Budupuk, Okam, Dikung, and Harak areas, while respondent number 2 also started claiming Marenga Ringte 2, both without any rightful claim. This was done by taking undue advantage of the fact that most of the petitioner's family members reside outside the locality. Consequently, the petitioner requested the respondent to relinquish their claims to the land in question. However, the respondents were reluctant to vacate their possession, particularly regarding so-and-so held by respondent number 1 and 2 respectively. And as a result, my lord will mark this. And as a result, a local kabang was convened on April 17, 2023 at Marianga village by the village authority, which include Lokam Tare, LGB, Sri Lokam so-and-so, Sri so-and-so, and so-and-so, to resolve dispute between the parties. However, the village authority was unable to reach a decision and the matter remains unresolved. Taking advantage of this situation, the respondents are persistently attempting to seize the land in question without vacating their designated area despite repeated requests from the petitioners. Now, my lord has noticed, after reading this paragraph, that the first blaze label authority, my lord, is in session of the case, my lord, and no verdict has been pronounced. But, my lord, the turn of event has occurred from page number 20. My lord will kindly come to order page 20, my lord. This is the first mail order, my lord. Second mail order. Then this is the first. This is the thereafter, my lord, on 18/2/2024, the purported, my lord, inter-village territorial Niel or Kaba was held, Miller. Order was issued. My lord, may kindly see, date is 18/2/2024. A written complaint, my lord, kindly see. A written complaint has been lodged by one series so and so, HGB, late so and so of village Maringa under Damin Circle, District Kurungkume against two series Jakpus, Kame, son of so and so, District Damin Circle, District Kurungkume, in connections with land dispute case by name Sonuk and Hatak Halang Hodik Ogam in Frontier Administration of Justice Regulation 1945, so and so from the date of commandments of this act. Therefore, the following GBs and AGB and GB is hereby appointed for their trial statement of the case as per local customary mail. Now the third paragraph, my lord, it says, the mail is fixed on 10/5/2024, my lord, at 8:30 a.m. at Damin ground. Both the parties, including the arbitrators, are directed to attend the mail accordingly. Further, the judges, arbitrators of the mail should submit a copy of case settlement to the undersigned, my lord. Now, my lord will see copy 2, my lord, kindly see copy 2. Here, the rest of the petitioners were not made party in this first mail order, my lord. Thus, in serial number 2, only Chapu Kame, who is the petitioner number 1, was informed, my lord. And then, my lord will see in the signature portion, my lord, Lokam Mangha HGB, Damin Town. And my lord will see the president ADPAGWA, Kurungkume district. Now, my lord, now because there is one thing, my lord, under section 5, these Gamburas are appointed. And in now section 3E has defined them as the customary court, and therefore they are the lowest civil court judge in the state of Arunachal Pradesh in terms of AP Civil Code Act. But, my lord, earlier judgment, there's Ige Tacha versus state of Arunachal Pradesh. There was a decision, I was party to this case, my lord. There, the proposition that I argued was whether the Gambura Association can pass an order to convene a mail. The answer was negative. No, you cannot. Except for the head Gamburas or the Gamburas of particular place having territorial jurisdiction only can convene the mail order. Now, my lord, kindly try to...
Yeah, but you see,
yes,
all said and done, this, in this writ petition,
correct.
This CRP,
Correct.
your prayer at page 13 is to quash the notice of
Correct.
9/9.
Correct.
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 By which the mail was fixed on 10/10.
Correct.
Now, by bringing this, what do you call this affidavit, you are projecting that there is already a mail order of 10/10.
Yes, my lord. Which
Correct.
was...
So if, no. But then you are traveling beyond your prayer in the writ petition, in this CRP. In this CRP, your prayer is only to quash the notice. Once the order is passed, this is infructuous.
That is correct, my lord. I'm coming to that also, my lord. Because pursuant to this 9/9/24 notice, my lord, at page 23, my lord, no Kewang was held, my lord. Because thereafter, we have filed the CRP and there is an stay order, my lord. In order to overcome that stay order, entire documents were backdated, my lord. This is how, my lord, we are agreed, my lord. The second point, my lord, why we challenge the impugn order is for two reasons, my lord. My lord, I'll come to one particular paragraph, my lord. My lord, kindly allow me to read two paragraphs. from my CRP, para 10 and 11. That it is most respectfully begs to submit that upon inquiry on reasons for a mail being not conducted and verdict being not pronounced by village authority on the day of mail, it has come to light that respondent number 1, whose late sister Chakku Yadav was married to younger brother Sri Lokam Tapit of Lokam Mangha, and resultantly the verdict was not pronounced as being influenced to the village authority. More so that being the position, the petitioner apprehends that if the mail in the present form is conducted, per se held under the chairmanship of Sri Lokam Mangha, will lead to a grave miscarriage of justice.
Yes.
Sorry, my lord, I got distracted with that.
Yes.
My lord, may I read again?
I'm here with you.
That it is most respectfully begs to submit that upon inquiry on reasons for mail being not concluded and verdict not being pronounced, my lord, that is, I am referring to the 17/4/2023 mail here.
Service report का है. Service report का है.
It's in order dated 03/2000.
No, I'm looking at something else.
Yes.
I'll tell you what is happening.
My lord,
I'll tell you what is happening.
correct.
You know, I was not being able to find this service report. You took steps on 5/10. And this service report says that the service was made on 27/11. That means after the mail order. Your order of stay was never communicated to the to this. There's a signature there. Please see the name. Sam Chiku, Saw Chiku. Down below, the signature receipt is by them. So the service on the authority is made on 27/11, which is after 10/10 order is
No,
passed.
correct, my lord. Correct, my lord. I have an answer for that also. My lord, kindly have my rejoinder kindly. I anticipated this. Here. Verified, no? Page number? Page 89, sure. Okay. My lord, kindly, my
There
younger,
is page 85.
yes. My younger says paragraph 5 is the answer to my lord's query.
It's okay, I'm there.
That the statement made in paragraph 10 of the affidavit of opposition is untrue and is denied by the answering deponents. In this context, your humble deponent respectfully states that an interim order dated 4/10/2024 was passed in CRP number so and so by this honorable court, and the certified copy of the order was received from registry on 5/10/2024. Subsequently, on 8/10/2024, The petitioners went to Damin to serve the certified copy of the interim order dated so and so, to Sri Lokam Mangha AGP Damin at his residence. However, Sri Lokam Mangha refused to accept the interim order and upon learning about it, began to verbally abuse the petitioners. Despite repeated requests for him to receive the interim order, he remained yielding and threatened the petitioners.
No, there is
Once-
something wrong. 85, page 85.
Page 85, Manoj.
85, first line is late Chakku Tasa.
Let's see.
This affidavit filed today.
Yes, Manoj.
This is 85 in my copy.
Page 80 is for which reference, Manoj? On which issue?
No,
Manoj?
No, you were saying about page 85.
Yes.
I was reading 85 is something else.
No, Manoj, 89.
89.
89 is the answer. Manoj.
Yes, para 5.
Paragraph 5, Manoj. That the statement made in paragraph 10 of the affidavit in opposition is untrue and is denied by the answering deponents. In this context, your humble deponent respectfully states that an interim order dated 4/10/2024 was passed in CRP number 46/2024 by this Honorable High Court. A certified copy of the order was received from the registry on 5/10/2024. Subsequently, on 8/10/2024.
Cannot be accepted. This statement cannot be accepted. The simple reason is that the order of the court, which was passed on 4/10/2024, did not give you liberty to serve by Dasti. As per this order, petitioner shall take steps for service of notice upon the respondents by registered post with AD as well as by usual process within 7 days from today.
We have taken the steps, Manoj.
That's what we are showing you. The steps you have taken went to reach the court on 21st of November. Processed it on 27th of November, which is beyond 10/10 when the order was passed. Now you are making the statement in paragraph 5 that you went, but this is not in accordance with law. Therefore, service by mode of Dasti mode may not be found acceptable by this court.
Fine, my word. Otherwise, I could have resorted to Order 5 Rule 20 as well. But the moment.
No, Order 5 Rule 20 could not have been invoked because Order 5 Rule 20 is substituted service which can only be made if there is evidence before the court that somebody is refused service.
I agree, my lord. But my lord, kindly appreciate because
this will be service within the meaning of Order 5 Rule 9 at best.
Order 5 Rule. Yes.
Where the registered post can be sent by you.
Correct. We have taken that. But then, my lord, a person is prejudiced against us. He has a predetermined thing. Because in paragraph 10 of my CRP, I made a categorical statement, my lord. So therefore, my lord, he refused to accept this. Otherwise, my lord, the last occasion when the matter was listed, my lord, that caught my head that day. So I told my learned friend, saying that if this order is passed on 10/10/2024, my CRP become infructuous and is no more any surviving lease.
There's another reason.
Correct.
You see, this order was passed on 4/10/2024. Notices may determine 4 weeks. There is a judgment of Supreme Court in Hyderabad, Alvin, Hyderabad Alvin Limited. In that case, the Supreme Court has held that service made after the due date is no service at all. Therefore, 4/10, 4 weeks would be technically it is either 310 or 410. We don't go by the number of days, but technically 4 weeks would be 410 to 411. Service is made on 2711. So in this Hyderabad, always the judgment is to the effect that the notice issued and service not made would require the court to issue a fresh notice. And service of notice after the due date is no service at all. Based on that, I have passed a lot of orders.
My lord, rightly be so. That is absolutely right. There is no quarrel on this proposition.
Once this
But,
notice is served
no,
on, once this notice is served on 2711,
Correct.
then this you'll have to file a fresh one to challenge that order.
Correct, my lord. Well, correct, my lord. So therefore, when the last occasion, the matter was listed, when he filed the affidavit in opposition, disclosing all those, my lord, impugn order, including the impugn order, then immediately I brought before the notice of this honorable court. I made a fair submission. Well, let me seek instruction from my whether you have served a copy of interim order, a copy of the interim order passed by this honorable court or not. If you have not served, on or before 10/10/2024, I have no case. I will have to withdraw. Then, my lord, till such time, I have made a categorical statement in para 10 and 11 also, my lord, in my CRP. There I said, during operation of the interim order, and the copy has not been served to them. But here, my lord, they have acted smartly. So therefore, I advise my client. My client says, sir, would you file a contempt? I said, no. If this order at all was not served on or before 10/10/2024, then you cannot file a contempt. Unless or otherwise, challenge filing an appeal before the district and session court against this. But, my lord, be that as it may, the main question of law that I am arguing in this case is for one particular reason, my lord. One particular reasons with the legal fiction is that when the lease is pending, my lord, before the village authority, is there any, is the statute empowered the entire territory village council to take up the case so moto? The answer is no, my lord.
No, answer maybe no, but now when the stage of notice is over, then perhaps in a new petition, we may give that opinion, but not in this case, it becomes
Correct, my lord. Because
we give you liberty to withdraw it and file it and take all these grounds.
I do that. And in the meantime, my lord, we have initiated complaint against them because whatever consequences will follow, my lord. My lord, on record, my lord, on record, I am making this statement, my lord. This 10/10 order, my lord, no kava was held in the open ground, one. Number two, the verdict or the decision was not pronounced in the open court, my lord. There is a video recording. This certificate has also come. It was drafted by someone and the Lokam Mangha AGB, my lord, Damin Circle. He called all other members and asked them to put their signatures. My lord, I am just making the statement
No,
because
it's okay, but you see, I have a very bad habit of myself in that place. So if I put an accusing finger towards X, 3 fingers are pointing against me.
Newton third law of motion.
I don't know, but these 3 fingers are pointing towards me. Newton is far more logical and superior brain than I am having. But the fact is that you see now what happens is that in my daily judicial routine,
correct,
in order to save time of the court, what I do is that I say that I will pass orders in the chambers. And not one each day, maybe 2 or 3 orders, I put it in the chambers. The bad effect of that is that I have a slip disk. I sit in the chamber while because I get up at 7:38. By the time I leave chamber, And just to save the judicial time, I do it. But those orders are not dictated in open court. At least 2 or 3 orders a day is not dictated in the open court.
My lord, I can understand.
Correct.
My,
So it is very hard to presume that somebody else would have written the order.
Fine, my
And
lord.
therefore, it is only when you challenge that order of 10-10, then only we can apply our mind. Otherwise, I think that, okay, this is something which I also do.
Correct.
And not once, every day, even the last working day of the court. I took 3 matters at home and to dictate the orders. So I'm doing it regularly.
24-0.
First of all, I'll have to change myself and then say that others will also not do it. But then you see, in the entire day, I'll take up 2 or 3 matters only. If I dictate orders and in the open court. So that's why I try to save judicial time.
I understand.
And in the process, this is what has come up.
The due course of deliverance, my lord.
So therefore, I think, Mr. Tara,
My lord.
although your argument is good, but I think you should reserve it for the next petition.
I, with greatest respect, my lord, kindly grant me liberty.
We give you liberty.
But limitation will not count, my lord.
No, we give it because today you are withdrawing it.
Correct, my lord. I am grateful, my lord.
Apart from that, they can appeal this order also. There is appeal provision in it. Yes.
Okay.
There is a remedy available, Lordship.
Okay, we record your statement. Mr. Tara, I just ask you because since you have been making those submissions, you want us to record about the service on 2711, or I just give liberty to you and then end the matter?
Liberty and then.
No, the discussion with regard to your steps taken.
I mean, no, my lord,
service.
that's really not required.
Mr. T.T. Talan and counsel for the petitioners. Also heard Mr. T.
T. Tanya.
T. Tanya.
K. Tanya, Lordship.
K. Tanya.
Yes.
Sorry. K. Tanya, learned counsel for the respondent. You for all the respondents?
Yes, Lordship. There's only two respondents.
For the two respondents. Next paragraph. In course of deliberations, the learned counsel for the petitioner is referred to the additional affidavit. Affidavit in reply filed on behalf of the respondents, and it is submitted that this revision, it has come to his notice that on 10/10/2024, mail, so what should I call it? Mail decision or
Mail judgment, Lordship.
Mail judgment.
Yes.
Mail
As per
judgment
Nishi customary law.
Mail judgment as per the customary law was passed.
In page 60, it's there in page 60.
Huh?
Page number 60 is there.
60?
60. In page number 60. In affidavit in opposition.
Available at page 60 of the affidavit in opposition.
Section 22.
So, accordingly, it's submitted that as the said mail order dated 10/10/2024 is not included in this. In this application, he is prayed for liberty for withdrawing this application first to challenge to make a consolidated challenge to the notice impugned in this application, as well as assail the mail judgment dated 10/10/2024. Next paragraph. The learned counsel for the respondents, though has not objected to the prayer made, but it has been submitted that the mail judgment dated 10/10/2024 can otherwise be assailed by filing a statutory appeal.
Under AP Civil Code, they can appeal 15
Under?
clause. Arunachal Pradesh Civil Code Act, section 15 clause 3 and 4. They have means remedy
Under section 15 within bracket 3 and 15 within
Within a
bracket 4
period of 30 days, my lord.
of the Arunachal Pradesh Civil Codes Act.
They can appeal to apex as well as civil judge senior division.
Learned counsel for the petitioner submits that as is withdrawn the present application with the comma, the it may be ordered that the limitation would not be a bar for the entertaining of this consolidated challenge. Next paragraph. The what is the considered opinion that as far as the issue of limitation is concerned, although this court would refrain from extending period of limitation, but it is always open for the petitioner to explain the delay approaching the court, which would be an explanation within the meaning of section. This Limitation Act, it should be limitation within section 14 of the Limitation Act. You get the Limitation Act. Next paragraph. So be that as it may, comma is uh, 14. Next paragraph. Accordingly, the court is inclined to permit the petitioner to withdraw this application and to
Correct.
and to avail such remedy against the notice impugned in this application as well as the mail judgment dated 10/10/2025 2024 in such manner as the petitioner may be so advised. We are permitted consolidated, so anything can come in now.
Everything comes for that section 14 minutes. Much obliged.
Highly obliged.
Lordship, I am appearing on behalf of PO
Yes.
for applicant. Lordship, here in this matter, we are supposed to file rejoinder application. The applicant was supposed to sign in rejoinder application.
Rejoinder against what?
Against my objection, my lord, in the IA.
In the IA.
in the IA 146. They filed for impediment, my lord. I filed an objection.
You want to impede yourself?
No, my lord, I'm for the writ petition. My lord.
You're for the writ petition.
It's
You,
the
you
impediment.
have applied for impeding.
Yes.
Yes.
The issue in the impediment petition, my lord, the other parties in the writ petition have not been made added as respondents in the opposite parties in the IA. That is,
I did not get it. Please repeat again.
my lord, in the IA, my lord, the other respondents in the writ petition have not been arrayed as
It's
opposite
not
parties.
required because
My
it's
lord.
essentially asking relief against you.
My lord, and other aspects are there, my lord. It's a welfare society and they want to claim the benefits from the forest dwellers' rights, my lord, in a reserve forest. My lord, we are claiming under the Scheduled Tribe Forest Dwellers Act. They are not scheduled tribes, number one, my lord. Number two, it's a welfare society. It does not have a locus. If there are persons who are residing there, that may be there. My lord. The applicant will not be a necessary party, nor a proper party, my lord. Applicant is a society. Society of persons, my lord, who are not recognized as scheduled tribes. And our prayer in the writ petition, my lord, is for
Still, Mr. Nair,
Madam.
they, in this interlocutory application,
Madam.
the applicant claims that this Namdapha National Park
Madam.
is a home to several Yobin villages.
Madam.
Now, there are two ways to look into the matter. Number one, we take a view that they are necessary parties because if their villages are there, they'll have a right to representation, number one. Second is that we accept your objection that he is not a scheduled tribe and therefore he may not be entitled to any compensation. But then we must say that no order passed would be adverse to the interest of that community. And therefore, to implement that, your petition gets stalled because unless the authorities arrive at a decision and give a categorical finding that no part of this Namdapha forest is covered by any this till then your claim of compensation will never be processed.
My lord, ultimately an inquiry has to be made, my lord.
But that inquiry, you see, first the inquiry would be not about you alone. The first inquiry, because of the orders of the court, would be made whether they are there or not.
My lord, that aspect is there. But my lord, our prayer in the writ petition, my lord, was restricted only to Kamku village, which was inhabited by the Singphos. There was no Yobin tribe there. And the Yobins, my lord, it was only in 1994 that they have been recognized as citizens.
That's okay, whatever has happened. Please come to your prayer here.
Page 25, my lord.
Yes.
Starts from page 24, I'm sorry, my lord.
It's okay.
Directing respondent to pay the villagers of PC village and erstwhile Kamku village in and around Empen area, being descendants of the original inhabitants of the area belonging to Singpho tribe, whose lands have been included in it. It is only for the Singpho tribe.
PC and Kamku.
PC and Kamku. Kamku village is no longer there, because the persons in Kamku village, they have been displaced because of the forest. And PC, and it is community land, my lord. The Singphos, my lord, own the community land. That community land has been taken, is included in the Namdapha Reserve Forest, my lord. Namdapha National Park. PC village is still in existence. Kamku village is not there. And in these two villages, my lord, there was no Yobin. The Yobin tribe, they were recognized as citizens of India only in 1994.
If somebody is living there, they can come for compensation.
My lord, if that inquiry is directed to be made, my lord, within a time frame, my lord.
Yes, you have a copy of your petition?
Pardon?
You have a copy of your petition? Do you have a copy of your of this IA and your objection?
My lordship, actually, I'm not well acquainted with the fact. So conducting counsel is from Shillong. So I'm appearing just on behalf of him.
I don't know, you see, there are 4 or 5 or 6 advocates who are signing the Wakalatama. One advocate is not there. Doesn't mean that we have to adjourn the matter. This interlocutory application for impleading. It looks so bad for making an adjournment in these small applications. And this, the lawyer who is the arguing lawyer, his name is not there in the list of absence. So anybody and whoever signs the Wakalatama will have to do it. He's not a regular member of the bar, that means if he's coming from Shillong. He doesn't show his name in the letter of absence. And the counsel, Mr. Nair, he comes from Guwahati. Just, you can't take an adjournment like that. this village in which respect of which the prayer is made is PC village and erstwhile Kamku village. You are saying that your Yobin villages are Nagodi, Nwazakha, Agruchi, Nibodi, Josadi, Midodi, Yachile, Sichoto. It doesn't include this.
No, madam.
You can't be impleted. It just can't be impleted. That's not your village. If you have a right, you'll have to establish it in your case. You can't object to the writ petition by having a affidavit in opposition. I'm sorry, we are allowing this, dismissing this interlocutory application.
Lordship, kindly short date may be given to file our rejoinder application.
Why- You see, you should have informed him if you don't want to do it. You can't allow this lawyer coming, lawyer standing here and you don't giving the advance information.
Lordship, due to health issue, conducting counsel is not unable to attend.
We can't make an inquiry. He's not a member of the bar. His name is not reflected in the letter of absence. We're sorry, we are dismissing it, but we give liberty to this applicants to make a separate claim in their own right, if so required. We'll record your prayer for adjournment, but we'll refuse it. Your name?
Emata.
M?
Ata.
You're not a lawyer here.
Lordship, I'm on behalf of P. Obin.
You're appearing for P. Obin.
P. Obin.
And your name is?
Emata.
But where are the other 1, 2, 3, 4? Other 4 lawyers, where are they? You see, this in this case, 5 lawyers have signed the Wakalatama. No advocate is on record. It's not permissible. We're sorry, this practice cannot be encouraged. Five lawyers are there on record, nobody appears, and then you say that you are appearing on instructions. You just can't allow that. Mr. N.
Ratan.
Ratan, Learned Counsel, appears for the applicant on the instructions of Mr. P. Yobin, the Learned Counsel holding the brief for the applicants. And it's submitted that the counsel holding the brief has some medical issues for which he is unable to attend the court. And accordingly, it is for an adjournment. Next point. this being an interlocutory application for impediment, the board finds no reason to adjourn the matter. Also, as the name of the council holding the name of 5 council, learned council, who signed the work document, but their names are not reflected in the letter of absence. Next paragraph. By filing this interlocutory application, the applicant, which is the Yobin Welfare Society, represented by its General Secretary, has prayed for impeachment in the connected WPC 119 AP of 2024 as respondent number 12. Next question. It is projected in this interlocutory application that the applicant is a society which is duly registered under the Societies Registration Act, 1860, is applicable to the state. In paragraph 2 of this interlocutory application, it is stated that the applicants are aware that the opposite party, how many are there?
Madam, 2
parties, opposite parties, writ petitioners.
Writ petitioners 2, my lord.
Have filed WPC 119 AP of 2024, claiming compensation for the villagers of PCPI SI and
Erstwhile Kamku.
No, here they are writing M pen, M apostrophe pen, capital P E N. P is E N. M apostrophe P E N pen. Villages for converting their village land into Namdapha National Park and Tiger Reserve. Full stop. It has been projected that if the said writ petition is heard without the applicants, it will have large ramification against the interest of Yobin community as a whole. And accordingly, it is projected that the Yobin community is a necessary party in the writ petition. It is further projected that the applicants had historically been submitted to discrimination and deprivation of their rights. And it was the Yobin tribe that suffered eviction from their own villages when Namdapha National Park was declared. And accordingly, it is projected that the applicants, applicants tribe had suffered long and silent deprivation. That's why it is stated in paragraph 5 of this application that the Namdapha National Park is also a home to several Yobin villages, namely, these names are there in page 6, and I can't spell correctly, huh? Page 6, I flagged it. Paragraph 5. Put a blue flag. First off. In paragraph. No, it is further stated that none of these villages have been recognized or given rights under the scheduled tribes and other traditional forest dweller within bracket recognition of forest rights bracket was Act, 2006. And it is also, it is further stated in paragraph 6 of the application that in the meetings, in the meeting held on 21/2006, although they were assured by the then, what is the full form of IGF?
Inspector General of Forest.
Acha. IGF, symbolic and director within bracket PT bracket closed, capital M small o, capital EF, Ministry of Environment and Forest, comma, Government of India, although assured that no forceful eviction will be carried out against Yobin community, but the park would not recognize the rights of the Yobin community. Let's go. The submissions made by the learned counsel for the respondent. Respondents. Next paragraph. It is clear from the statements made in paragraph 2 of this application that the applicants are aware that the are claiming the respondents have filed WPC 119 AP of 2024, claiming compensation for the villagers of PC, PISI, PC and M apostrophe pen villages for converting their land into Namdapha National Park and Tiger Reserve. It is clear from statements made in paragraph 5 that none of the that the applicants do not claim to be the residents or villagers of PC, PISI, PC and MPEN villages. And accordingly, the applicants have not been able to show that they have any vested right in as villagers of PC and MPEN villages in the absence of any pleading in that regard. Next paragraph. It may be stated that in paragraph in prayer A, small a, prayer A of the writ petition, comma, the respondents are seeking issuance of directions on the responding authority to pay the villages of PC village and the erstwhile Kamku village in and around the M apostrophe pen area. Therefore, the villages referred to in paragraph in prayer A of the writ petition are not the villages where the applicants claim to be having any legal right or that at any point of time they had resided in the said villages. According to command, the court does not find any reason, any justifiable reason to impede the applicants as responsible as their appearance and participation in the writ petition is not found necessary as in view of the names of villages disclosed in paragraph 5 of this interrogatory application. Next paragraph, therefore, comma, if the petitioners have any, the applicants have any claim whatsoever, comma, they would have an independent right to pursue the same. Stop. Next paragraph, accordingly, comma, if while rejecting the prayer for adjournment as made by the learned appearing counsel, this application stands dismissed. Mr. Ratan, you are also there? Or?
Here in the IA, we have not been made part.
You are not made parties. Okay.
My lord, if I may, my lord. My lord, prayers B and C, my lord, also the names of Kamku and PC villages are there, my lord, in the writ petition, my lord. Prayer A, B, and C.
Okay, A, B.
A, B, and C, my lord.
A, B, and C, okay. A, B, and C. Okay.
Deeply obliged.
And the writ petition?
Could it be, because we have been served a copy of an affidavit, my lord.
No, just a moment.
Some
The
instructions.
petition is Mr. P.G. Nair and counsel for the petitioner. Mr. No, first is the DSGI. You are appearing for? One is your name? A? On behalf of, just write it down. I may make mistake in names. Counsel appearing on behalf of Mr. D. M. Kato, the DSGI, corresponding numbers 1 and 3. And Mr. N. Ratan, Leonard, additional advocate general for us, the other respondents.
Yeah, 2, 4 to 12.
Land management.
For the other respondents. Next paragraph. It's ready for hearing now?
My lord, our affidavit rejoinder may be, I'll obtain some instructions on that. Some documents, my lord, since it pertains to a long. Could it be, my lord, sometime in the middle of May, my lord, if it is not inconvenient, my lord?
Okay, next paragraph, the learned counsel for the petitioner pays for some time to obtain instructions and to file affidavits, comma, if so advised. Sorry.
Sorry.
So, affidavits, if any, be filed within 5/5/2025. Based on
14th, my lord, if it is not inconvenient.
14th, okay, 14/5/2025.
My. Deeply obliged.
May I please, ma'am.
Please.
My lord, here the petitioners are challenging the action of the respondent authorities.
Just a moment. Just a moment. But we can't do anything.
My lord.
What is your prayer?
My lord, firstly is the setting aside of the order, my lord.
You want to quash your own orders?
My lord, of course.
Hmm?
Yes, sir. And secondly, that
Where is that order?
that order, impugn order is at 27, ma'am. Page 27. We have been just randomly picked, appointed from where there is no promotional scope, and till date there is no RR, my lord. Otherwise, from the post of
You see, number one, in this recruitment process, did you face the normal recruitment process of advertisement, applying, and then getting that competing with others and getting the appointment?
well, that appointment, our initial appointment order itself is at page 88, annexure on page 20, my lord. We were
20.
20, my lord. We were appointed in the year 1988.
Okay.
By following due procedure, my lord. This they have not disputed, my lord. Our name is at petitioner 1 is at serial number 26, and the petitioner number 2 is at serial number 28, my lord. Page 21.
Okay. Yes, Mr. Pame.
Our stand, my lord, is when they will get give appointment as AMI, my lord, that was a promotional post, my lord.
That was
Promotional post, suppose, my lord, they at that point of time they were AFA junior, my lord, junior. Now A senior and AMI was equivalent post, my lord. Accordingly, in terms of seniority, my lord, they were given AMI.
Seniority is as per which notification?
In terms of their service in AFA junior, my lord.
Where will you find that service rule?
No, my
that
lord.
is-
Till date, my lord, I have annexed the RTI also, my lord. That submission coming from my friend, my lord, is my lord, wrong, my lord. Because till date, my lord, no RR has been framed, my
No,
lord.
we'll be having more information.
No,
It is in the under the RTI we have been furnished that it is still under process, my
The
lord.
RTA may not know. Mr. Pame, can you
Yes.
tell us and show us that service rules? Or
My
the
lord,
notification by which?
in AMI, my lord, I accepted, my lord, there is no recruitment rule, my lord. Till today, my lord, AMI, my lord.
No, you see, we are asking you a question for a particular purpose.
My lord.
Please come to page 20 of the rate petition. From this order at page 20, can you say that the appointment order is not a permanent appointment order? Or not a regular appointment order?
It is a regular, we understand.
Regular. Any second thought? No. It's a regular appointment. Come to page 27. Now you see that they have been regularized. How can a permanent employee be regularized?
This, my lord, page number 27 is pertaining to, my lord, assistant marketing inspector, my lord. Earlier is
Petitioner says that he's the person in who is affected by it, and therefore he wants termination of this order.
yes, my lord. Yes, my lord. That's why I have some, my lord. Earlier, my lord, they were given regular appointment in the post of AFS junior, my lord. Now AFS junior, my lord. AFS junior, my lord. Now their promotional post, my lord, at that point of time, but AFS senior, my lord. Now, when they were given AMI, my lord, that was equivalent post to the AFS senior, my lord, promotional post, my lord. Now, my lord, after so many years, my lord, they are agreed because, my lord, now the pay of AFS senior, my lord, and junior has been enhanced, my lord. But when they are given appointment, it's a AMI.
By which order? By which order that has happened?
If my lord, my affidavit, my lord, kindly turn to page number 78, my lord. I have our stand, my lord, clear, my lord.
78.
78, my lord.
Yes.
78, my lord. Para 6, my lord, I'm reading, my lord.
Yes.
As regard to appointment made in para 9 of the writ petition, the respondent submitted the appointment of petitioner to the post of assistant marketing inspector was as part of seniority list. The post of assistant marketing inspector was equivalent to the post of AFS senior, my lord. That was their promotional post, my lord. So they, without any demon, my lord, they accepted, my lord, at that point of time, my lord. Now, what change has happened after this, my lord? AFA pay scale of this AFS junior and senior, my lord, has been enhanced, my lord. Now, a pay of AFS junior is equivalent to AMI, my lord. Page number 79, my lord, para 10 also would be relevant, my
No,
lord.
Mr. Soki, I thought this was 2024 order. You are challenging the 2004 order now.
2004 order.
Under the various judgment of Supreme Court in a service matter, a belated challenge has to be as a thumb rule dismissed.
Well, of course, there are certain delays. There's a delay is there.
No, 21 years. After 21 years.
This was filed last year, my lord. So around 20 years. Of course, we admit there is a delay.
It's 21 years.
My lord.
20 years you have woken up.
No, my lord. But
Exact case of Rip Van Winkle.
no, my lord. Here we have been approaching the Department of that is another issue. My
No,
lord.
that's okay. But I remember this kindergarten story of Rip Van Winkle. I hope you have read it.
My lord.
You have heard the story of Rip Van Winkle.
No, my lord. I'm sorry, my lord.
No. You have done missed something in the life. This man slept for 20 years. When he woke up, he found a different world.
Man.
It's a story of Rip Van Winkle. He slept under the tree and then he woke up after 20 years. He found there is a different world now.
I will try to, my lord,
Read it now.
do that also, my lord. Since my humble submission is that, my lord, even by a flux of time also, my lord, the wrong that has been done to me, the fundamental, my lord, that
You have
cannot
accepted
be,
for 20 years.
there cannot be waiver of,
Rights that are surrendered.
there cannot be waiver of that. Another aspect, my lord, other than this, my lord. Firstly, my lord, my submission is that since, my lord, AFA junior, my lord, they can go up to the post of agriculture development officer, my lord. Ours till date, my lord, Even though we have approached several times, my
You
lord.
can only have an option to the represent before the government to give every for this is something which the court cannot do it.
No.
A court cannot create a promotional avenue for you.
No, of course,
Why
my lord.
it's not?
That's why, my lord, my submission here is that, my lord, my conditions, service conditions, my lord, it has been altered without giving us any opportunity, my lord.
After
And these
20
persons,
years-
my lord,
After
my lord,
20 years,
yes, ma'am.
I was reading this 2004 as 2024.
My lord, these persons, my lord, because these persons, frankly, my lord, submitting, my lord,
I can only say I'm sorry.
this, and one more aspect is there, my lord. Similarly situated persons, they are getting higher pay than that I have also mentioned, which the department is saying, my lord. That is a mistake, my lord. And the stand that has been taken
You
by
see,
the
but
department, my lord.
But whatever has happened,
My lord.
this is something which is beyond the jurisdiction of the court. We can't run administration.
My lord. Just, my lord, if I may take your lordship, my lord.
No, I accepted.
Yes, ma'am.
We accept your condition, but then also the court cannot run administration. We can't say who is to be given promotion, what revenues should be rated.
No, my lord, that is another aspect, my lord, who should be given promotion or not, my lord. My basic issue is that my service conditions could not have been altered like that. And more particularly now, my lord, 10 persons, my lord, AMI, who were just picked up, my lord, without any opportunity. And
Challenge that procedure. You also claim that.
that procedure, it is under challenge, my lord. This is the order, my lord, which is under challenge, my lord. This is the order by which we have been given appointment to the post of AMI, my lord, and that is under challenge.
That is 2004.
Yes, my lord.
We did not entertain. It's a still claim.
And then just one more aspect, if your lordship would come, my lord.
Yes.
Just at page, my lord, 67 onwards, my lord.
67 onwards.
67, my lord. 8th series, my lord.
Yes.
This is the petitioner number 1, my lord. Salary slip of petitioner number 1. Page 67, man.
Yes. Yes.
So and so, my lord, total page there, my lord, to see, my lord.
Yes.
Next page, my lord, is the petitioner number 2, my lord.
Yes.
It's AMI, my lord. And page number 3, my lord, will say this is the AFS senior, my lord. My lord, notice the pay amount, my lord, at page 69.
We can't say anything about this.
And no, just my lord, why I'm saying that there is a
I'll tell
discrimination
you.
also, my lord, come just one more document, my lord.
I'll tell you, in the principal seat of Guwahati High Court, there's a employee who is of grade 4, and incidentally his drawings have for the new recruit of grade 3. Because of the years put in the service, by every annual increment, a grade 4 is getting more salary than the grade 3 person.
No, my lord, that is, my lord, there I'm showing, my lord, page 73, my lord, will come once.
Have you seen that? 92,000.
No, page 73, my lord.
And there is page 73.
Page 73.
92,284.
Yes, that is also one AMI, my lord. Even in the same cadre also, they are giving different pay, my lord. The petitioner and the petitioners, my lord, the petitioner 1 and 2 is at page 67, my lord. We are getting 82,000. Page 73, 74 is the AMI. Same cadre, my lord. They are getting the salary of this AFS senior, man.
If there's a pay disparity, then there's a anomaly committee.
My lord.
In the
My
pay
lord, yes,
committee.
my lord. Pay anomaly, my lord, that is of course there, my lord. But that is not related to some other cadre I'm playing some. Within the same cadre also, my lord, they are giving different pay scale. It's not a case where I'm claiming parity with some other cadre, my lord. Here is a case within the same, my lord. Otherwise, my basic case here is that the conditions of my service could not have been altered like
Please
that.
come to page 16 and 17.
16.
Incidentally, there is not your prayer.
My lord, I'm praying for that is my lord, my prayer is also for giving all the benefits also, my lord.
I'm sorry, Mr. Soki, you'll have to take an appropriate steps in accordance with law. Heard. Mr. D. Soki Leonard, counsel for the.
My lord is sorry to interrupt, my lord. My lord
Yes.
is disposing, my lord.
Yes, I'm disposing it.
Yes, my lord, and I will just rely on one judgment,
Yes,
my lord.
Yes, yes, why not?
Regarding the delay, my lord, this was by recently, my lord, this is 2024, my lord, by 3 judges, my lord. This was regarding one benefit, my lord, that person, my lord, which was supposed to be given to him in 1986, my lord. But after superannuation, my lord, in the year 2008, for the first time, he raised those issues, my lord, before the tribunal and before the High Court also, my lord. There, my lord, those were dismissed, my lord, for delay, my lord, delay in leges, my lord. So, my lord, regarding that, my lord, starting from page 20, my lord. No, paragraph 20, my lord, at page 10. Starting from paragraph 20, my lord, but where the discretion, my lord, of this honorable court or the constitutional courts under Article 226, my lord, it has been explained. Then 2021, I'll just read one paragraph 22, my lord.
You see, you have seen the facts of this case.
My lord.
You have read the facts of this case.
My lord.
Here, what had happened was that this man was a policeman.
My lord.
There was a attack dacoits in a bus, and he was traveling by it. He used his service revolver, killed the dacoits,
My lord.
and the very hardened criminal was killed.
My lord.
And the superintendent of police recommended his name for a police medal.
My lord.
And in the meantime, this nothing happened, and he is superannuated.
My lord.
He kept on knocking doors of each and every authority that he was entitled to a
No,
medal.
but he raised that issue for the first time in year 2020,
Yes,
2008. Raised
It's a
the
case
issue.
of, you see, it's a case of where this man has convinced the court that he was entitled to a medal, and therefore the court says the court still doesn't give him medal.
No, my lord, this
It gives him what you call reward of rupees 4 lakh.
my lord.
This medal was still not given. You see, the lordships in the Supreme Court of India have a lot of power.
Yes, my lord. Paragraph 22, my lord, regarding that delay in legislation, what fundamental rights, my lord?
Not in service matter.
Where there is a violation of fundamental rights.
Also heard Mr. Alpamed, and I standing counsel for the Agriculture Department, representing all the respondents. Next paragraph. By an order dated 11/11/1998, the petitioners were appointed along with several others in the post of village level workers in Macedonia.
Sorry to
Huh?
beg your pardon, your lordship. Sorry to interrupt once again. Otherwise, my lord, can this be listed before some other means? I would like to try my luck.
No.
Because these persons are otherwise suffering, man.
Not permissible. Junior, issued by the Director of Agriculture, Government of Arunachal Pradesh. From the names of the petitioners appear at serial numbers 26 and 28. Full stop. It is not in dispute that the petitioners joined the said post. Full stop. In course of time, the post of village level workers within village workers was designated as agriculture field assistant by an order dated 19/5/2000. It is projected that the promotional post of AFA, this agricultural field assistant, that make it short, AFA for short. AFA within bracket junior is AFA within bracket senior. And the promotional post is projected to be filled up only by way of promotion from amongst AFA within bracket junior, having 5 years of regular service in the grade with 2 years of training. In GTC, Pasighat. Next para. It is the case of the petitioners that by an order dated 30 March 2001, the government of Arunachal Pradesh created 10 numbers of posts of assistant marketing inspector within bracket AMI for short. Full stop. And accordingly, the petitioners, along with others, who were then AFA within bracket junior, were appointed to the post of AMI. Full stop. It is alleged that those appointments were made on pick and choose basis. Full stop. The petitioners claimed that they were initially appointed on ad hoc basis, and thereafter their services were regularized by impugn order dated 15/10/2004. Stop. The learned counsel for the petitioners has submitted that the alteration of the service conditions of the petitioners was made without any notice or intimation to the petitioners, and their appointments were made without giving any opportunity to the petitioners to submit any representation. First. Next, it is projected that the petitioners had made a representation for their promotion from the post of AMI to the post of MI, IE, Marketing Inspector, on 29/2010. However, as the respondents did not take any action, the petitioners submitted another representation on 3/3/2017. Next, it is submitted by referring to the annexed documents that there are that although the respondents treat the post of AMI and AFA within bracket senior of equivalent status, but persons holding the post of AFA within bracket senior are getting higher pay than what the petitioners got as AMI. The learning counsel for the petitioners has also submitted that from the RTI applications, the petitioners have come to know that till date, no recruitment rules or any notifications have been issued by the department to regulate the services of assistant marketing inspectors and marketing inspectors. Accordingly, comment is submitted that without any basis, the petitioners are drawing salary which are less than their juniors. Who have since been promoted to the post of AFA within bracket senior. So accordingly, claiming that the petitioners are agitating the disparity in pay as the selection of the petitioners for appointment to the post of AMI was followed without following any procedure known to law by random selection. the petitioners have assailed the imperial order dated 15/10/2004 within bracket annexes 3 the Learned Counsel for the petitioner has submitted that the alteration of the terms and conditions of service is prejudicial to the interest of the petitioners, and accordingly praise that the said imperial order dated 15/10/2004 be quashed, and to give a direction to the respondent authorities to promote the petitioner to the post of AFA within bracket senior from the date when their immediate juniors were promoted. Next part. The learned standing counsel for the agriculture department has made a submission based on the affidavit in opposition filed by the respondents. Next part. Before that, you said that in support of his submissions that even if there is a delay in approaching the red court, delay would not be a bar for the court to exercise jurisdiction under Article 226 of the Constitution of India. The case of Ram Avatar, AUTAR Avatar Singh Yadav, YADAV, was the state of Uttar Pradesh and others, civil appeal number 13806 of 2024, decided on 4/12/2024, has been cited. Reported in within bracket 2024, bracket 0 Supreme within bracket SC 1311. Then we heard. Yeah, next madam. On a query of the court, you see first you say that peruse the writ petition and the documents annexed thereto, affidavit in opposition, and also considered the submissions made at the bar as well as the case law cited by the learned counsel by the petitioner. Next paragraph. At the outset, it is noted that from the initial appointment order dated 11/11/1988, thereby appointing '89 persons as were temporarily appointed to the post of village level workers within bracket junior. So from the contents of the said order, it does not appear that though the appointments were made temporary, the posts, the appointment was not permanent in nature. Because from condition number 2 of the said appointment, it appears that a condition was prescribed that the appointments were subject to condition that their retention in service will depend on their successful completion of the Gram Sevak training. The name of the petitioners are entered in the order dated 25/5/1989, sending them to undergo Gram Sevak. Don't say Gram Sevak, it's training at GTC, Pasighat. So the petitioners are not annexed any order, by virtue of which their services were regularized on completion of the training at GTC, Pasighat.
Since my lord did not, my lord had come directly to the delay. Otherwise, my lord, that annexure 2 is there, my lord, where we have undergone the training, ma'am.
No, that's okay.
That Grand Seva or that GTC.
No, this is not an order of training. This is order sending you for training.
Yes.
That's what you have recorded. We have said that you are sent for training, but you are not annexed any documents so that the application, their service have been regularized.
No, of course.
It appears from the contents of the impugn order dated 15/10/2004 that the petitioners were appointed on ad hoc basis as assistant marketing inspectors and that by the impugn order, the petitioners were promoted to the post of marketing inspector. And their services were regularized from the date of joining as marketing inspectors. Full stop. There's nothing on record to show that the petitioners had raised any objection before accepting the appointment orders as marketing inspector, by virtue of which the ad hoc service was regularized. Full stop. Next paragraph. Therefore, having accepted the impugn order dated 15/10/2004 2004. Merely because the petitioners have made representations purportedly on (29/2010) and 3/3/2017 would not be construed as a sufficient ground for asserting the order of their regularization of service in the post of marketing inspector, which was made way back on 15/10/2004. I.e. after comment that is on a challenge made after 20 years of accepting the fruits of the said regularization order. Next paragraph. There is another aspect of the matter. If at this stage the court interferes with the impugn order dated 15/10/2004, the court would relegate the petitioners back to the post of assistant marketing inspector, and that appointment would have to be treated as ad hoc basis. Therefore, the petitioners would have to face an hurdle of getting their service regularized. Therefore, to relegate a permanent employee with regular service to a service on ad hoc basis would rather do more injustice to the petitioners than give any benefit to the petitioners. Next paragraph. Moreover, in the parlance of service law, in the case of, just give a gap, I'll give that citation. It is well settled that delay in approaching the court after a gap of 20 years for challenging their own appointment orders would not be permitted, as there may be several persons whose seniority may be disturbed if the petitioners are relegated back to the ad hoc post of assistant marketing inspector. The next paragraph. The learned counsel for the petitioner has referred to the entertainment of petition for special leave to appeal before the Supreme Court of India, which was filed on 2023, which had a cause of action on 13/3/1986. And in this regard, the petitioner is relying on the observations made in paragraph 7 and 12.
No, my lord, and not on 7 and 12.
Then
I'm relying.
7 is the first observation of the Supreme Court on the ground of delay. The earlier petition was dismissed on the ground of sole ground of delay.
Yes, ma'am. No, my lord, I was on the proposition of law starting from paragraph 20, ma'am. I'm
20?
regarding 20 onwards, 20 to
20.
Yes, 20 to 20, 21 and 22, ma'am. I'm relying.
Oh, okay, you said para 20 onwards. That's right. We have carefully perused the case cited by the land counsel for the petitioner. Next. And we would refer to the brief facts of the said case. In the said case, the appellant was returning home from the returning from the headquarters to the Thana in a bus on 13/3/1986, and the bus was accosted, ACCOST, accosted by dacoits. At that juncture, the appellant used his service revolver and in the a dreaded criminal dacoit was shot. And he succumbed to the injuries. His act of courage and valiance, VALIANC, resulted in a commendation made by the Additional Superintendent of Police, Banda, and 2 years later, the Superintendent of Police, Banda BANDA, recommended the name of the appellant for a gallantry award. For reasons mentioned in the said order, said judgment, for one reason or the other, the President's Gallantry Award did not materialize for the petitioner. In the meanwhile, the petitioner had superannuated and turned septuagenarian, SCPTUAGENARIAN by then. He approached the Public Service Tribunal and then approached the High Court, only to have his applications dismissed. Oh, sorry, tribunal, not High Court. Tribunal dismissed. So, however, the appellant kept on pursuing the matter. Up to the office of the President of India, and thereafter approached the High Court. So accordingly, the High Court while dismissing the writ petition, recorded that the appellant was 83 years of age and he would not gain anything, any benefit on account of police medal, if awarded today. Full stop. The earlier round of leave to special, leave to sorry, petition for special leave to appeal. Not earlier, this special leave to appeal was listed on 20 February 2024. And on considering various aspects of the matter, the Supreme Court of India went on to refer to the inherent lack of jurisdiction by the tribunal and it is on those considerations, that the delay and latches in the case of the appellant therein was found to not come to the way for the court to entertain the said appeal with a specific finding at in paragraph 21 of the said order that the said judgment that a vital factor to be borne in mind is whether grant of relief in a belated claim is likely to cause confusion and public inconvenience, like unsettling matters which have long settled. And thereafter, the Supreme Court of India has observed that by entertaining this said matter, nobody else would have been affected. Stop. This observation, the said observation of the Supreme Court of India is the distinguishing factor in the present case in hand. Stop. Next, as stated hearing before, the impugned appointment letters were issued on 15/10/2024, 2004. Petitioners are 2 out of 8 persons who are appointed. Stop. If the petitioners are relegated back to their original posts of assistant marketing inspectors and to make their service ad hoc, it is hard to comprehend what would be the fallout of such an exercise. not such an order to relegate the petitions to uncertainty of an ad hoc appointee as assistant marketing inspector. Moreover, the petitioners having accepted the said appointment from 15/10/2004, the natural query of the court would be that what would happen to the pay which the petitioners have got as marketing inspector when they are deemed to be assistant marketing inspectors with effect from prior to 15/10/2004. The court at this stage not even complain as to who are the persons whose seniority will be affected by relegating the petitioners to the said uncertainty of ad hoc post of assistant marketing inspectors. So moreover, this 8 posts of marketing inspectors which was filled up would become vacant with effect from 15/10/2004. And therefore, there is no way that any actions taken by these persons who were not even holding the post would be, how would those orders be treated? Or actions taken by the petitioners as marketing inspector would be dealt with. Therefore, it would be a crushing effect on the administration if an appointment order which was accepted by the petitioners on 15/10/2004 is terminated at this stage and unsettle the settled position of service in respect of the petitioners and others who might be affected by this. Next, therefore, the case of Ram Avtar Singh Yadav within bracket Supra, cited by the petitioner, cannot be applied in a service matter to unsettle things. So accordingly, court finds no merit in the red petition and the same is dismissed. Under this circumstance, there shall be no orders to pass.
All right.
Obviously.
But it requires exhaustive hearing,
Today
so I have,
since we don't have time today.
yes, I have requested my brother, we fix it consensusly on 21st,
21st.
Yeah, reopening,
Mr. Tara, can you choose any day after this week of 21st? Because all the matters since this last week, we have been adjourning after vacation. It would be a lot of pressure on the registry.
Can it be on 23rd?
No, I'm requesting you not to avoid 21st week. Because since the last week when I'm sitting, all these matters are being adjourned.
28, fine.
Yes, no difficulty there. Okay.
May I also make a request? Item 29 and 30.
We'll take up one by one. I think except for short matters which we can take. Or other
I have
matters.
to leave for my hometown because my niece marriage is occurring from today.
Okay,
So I will not be there for the 1 week.
No, let me pass orders one by one. Item 17 first.
Yes, ma'am. Yes.
Both sides are represented. Due to positive time, matter could not be taken up today. Next para. As posed by both sides. List on 30/4/25.
29 and 30, my lord. I'm making a request. I have to leave my family
We'll take it
service.
up. We'll pass orders. Don't worry.
My lord,
Just give me 2 minutes time. 20 and 30. You ask somebody to be here. You may leave.
my lord, I have informed them.
Take it. Without Mr. Tara, my difficulty is that without the file, I don't want. to
I
pass orders.
understand.
It leads to a lot of difficulties at
I
times.
understand.
Item 29 and 30 pass separate orders. The same order, both sides are represented. As 30. Okay. Yes, Mr. Tara. Where are you? In this item, you see that's the difficulty when I adjourn it.
Okay.
In this case, affidavit in opposition is not filed. Who is the respondents? Anybody is praying for adjournment? No. For filing affidavits,
Item number 29, Lordship. Lordship is referring to item number
this
20.
is this is 18 to 21.
Yeah,
18.
No, ma'am. Ours is 29.
Oh, this is your 29. Okay. 29 and 21. Okay. 29. So this is 17. Again, difficulty. This you gave is 17.
Matters are tagged together. That's why some confusion.
I don't know. I find it very difficult to adjourn matters without knowing what I'm doing.
But
29, 30. 29 is in IA. Who's there in 29?
29.
Mr. Tara is left. Mr. Tara.
29 is a transfer matter. There's a stay order operating.
No, there's a reason I said, I told you.
Yes, Lordship.
This. Look at the cost title. Then you'll know what I'm saying. This one. First page of your cost title.
Sailor.
This is IA, but you're writing an application on Article 226.
Yours. Oh. We are otherwise not pressing on that.
Mr. Sharma, I told you I normally don't want to pass orders without knowing what I'm doing.
Yes.
Now what you say?
It's a mistake.
So we are
can't better.
You'll have to amend it, cost title.
Are pressing on that? Actually, we're not pressing because otherwise the pleadings are completed in this matter.
Okay.
And it's a small issue.
No, but then you will be taking a big risk. In this IA, you have made a mention that there is suppression of material facts.
Yes.
But then in the affidavit in opposition, that stand is not there.
Not taken.
Even my lord, record is also required in this case.
I
How
don't
the
know.
order was passed.
As it is.
No.
As it is, Lordship will not be thinking of the matter today since he is praying for an adjournment. I'll look into it and probably I'll make my informed submission on the next date.
My lord, without
A bit difficult to make my submissions right now on this
without
aspect.
any further adjournment on 21st, on the reopening day itself, my lord, because
Reopening day is very difficult, Mr. Tara. I can accommodate 30 any other day.
In that particular week, any other day,
Any other day.
particular day
you fix.
on 23rd of April.
IA. This is parcel order, separately order. Both sides are represented. Mr. A. Sharma, I counsel for the petitioner.
For the
Applicant.
Yes,
For
yes,
the
applicant.
applicant. For the applicant. Submit that mistake is crept in the cost title of this interlocutory application. And you take appropriate steps by next date. Stop. This on when?
According to their
22nd of April.
No, 22nd, that week I am avoiding because all matters are being adjourned for after vacation.
The entire week, Lordship wants to.
The registry will be in a difficult position.
So can we try on 23rd to 25th any date, Lordship?
Make it next week, 28th, you take any day.
28.
Last week we'll have to avoid because you see there are lots of bail matters are coming on this last immediately after opening. All matters are being adjourned for last 2 weeks. I'm here.
Can we try on 25th, Lordship? 25th, if possible. We'll try our luck, Lordship, 25th. So otherwise, pleadings are completely small issue. I request you, Lordship, to give it on 25th if possible. Let us-
25.
No issue, my lord. But
25.
interim order to continue to.
And this rate petition, we posted on same day.
Same day,
day,
Lordship.
same
Yes,
day.
Lordship.
This both sides are represented. This matter on with the connected IA on 25
April.
4 2025. Okay.
Interim order to continue.
Interim order passed in the
I'm grateful.
the petition stands extended to the next day of the state. Okay.
Obliged.
Now this is 18 to 21.
Yes, here, my lord, I am in it, item number 21, my lord. Now, respondent, my lord, has filed their affidavit in opposition in item number 18 to 20, my lord. I am told, my lord, that they will rely on the same affidavit, my lord. In my case also, my lord. So I pray for, my lord, copy of one affidavit in opposition, my lord, filed in other case, my lord.
By
Filed in these other 3 cases, my lord.
huh?
One case they have filed, my lord. They are saying, my lord, they rely on the same affidavit, my lord. In my case also, my lord. So I would pray, my lord, one affidavit, copy of affidavit in opposition may be given to me, my lord.
It was filed in which case?
It was filed in WPC 193.
193.
193 of 2022.
193 is this. Okay. All sides are represented. If a positive time matter could not be taken up today. Next column. Who's the affidavit?
Affidavit is still respondent, my lord. In item number 19, my lord, 193 to 22. Item number 19.
193, who has filed the affidavit?
We have filed, state has
Government.
filed,
Respondent number?
1980,
Respondent
respondent number 5, 8, and 9, your lordship, in item number 19.
5, 8, and 9.
Yes, your lordship. In item number 20, your lordship.
No, we don't know. You're
8 and 9,
asking me
your
to take up 193. I'm just asking you which respondent has filed the affidavit?
8 and 5, 8, and 9, your lordship.
5, 8, and 9. Okay.
Item number 19, your lordship.
In WPC 193 of 2022, say that all sides are represented. Due to positive time that could not be taken up today. P. Pangul and the government advocate shall provide a copy of affidavit in opposition filed by respondent numbers 5, 8, and 9 in this writ petition to the learned counsel for the petitioners in WPC 294 AP of 2024 and WPC 455 AP of 2024. Yes. In this two represented 294 and 455, because all sides are represented. It's P. Pangul and government advocate. Appearing for the state respondent numbers 4, 8, and 9. You also appeal for 4, Secretary Land Management.
So let's see. For land management, we have not filed, your lordship.
You're not filed, okay.
5, 8, and 9, we have filed.
Appearing for respondent was 5, 8, and 9. Provide a copy of. Government advocate submits that the affidavit in opposition filed in WPC 193 AP of 2022 shall be relied by the respondents numbers 5, 8, and 9. As per accordingly, that a copy of said affidavit be provided to the learned counsel for the petitioner. Next, list after 3 weeks. In 455, that's the same order. That's 294. Yes.
My lord, if it is not inconvenient, could the date be fixed, my lord? If it's not, my lord, 14th of May is convenient, my lord.
Okay, 14th of May. Okay.
Fine. Deeply.
Oh, bless me.
Okay, 23, I'm appearing for respondent number 5, Oil India Limited. What has happened in this matter is there was an eviction notice against certain, they are saying that they are from the forest. This particular area, there is a petroleum mining lease in our favor, and we were supposed to enter that area for this mining operations. Now, therefore, there were some people who are encroaching upon those areas, and the forest department issued eviction notice. Now, that is under challenge in this honorable court, in this litigation, and there is a stay order there. So, Lordship, now that issue, whether they were actually occupying forested land or because their ground is that this is a revenue village that they are residing, and therefore an eviction of this nature cannot be done. So now that issue has to be decided between the petitioner and the forest department. But then our difficulty and predicament is this mining lease that we have. We were supposed to go for exploration. Now that has been stalled because of this dispute between the petitioners and the forest department. I was therefore praying before Lordships that the matter could be heard.
But then unless that is heard, your mining lease will have to wait for some time.
Yes, Lordship.
Readings are ready.
They have filed an affidavit. We have filed our affidavit. The forest department has filed an affidavit. The forest department affidavit, they say that yes, they are encroaching upon forest land.
This is item
This
number
is 23. This is Deung Reserve Forest. Affidavit का copy है क्या आप लोगों के पास? उनको मिला नहीं है copy.
Ah, okay. So that all sides are represented. Next, Mr. A. Sharma, Runner, counsel for respondent number 5.
5, Lordship.
I submitted that as the case is ready as regards service and all the pleadings have been exchanged from a matter be listed for hearing. Accordingly, court is inclined to issue rule returnable forthwith without requiring the petitioners to take first steps. This is the matter for hearing.
In the month of May.
15/5.
Yes, Lordship. Month of May.
The Thursday, 15/5/2025.
Applies, Lordship. 15/5.
Item 23.
Applies.
This is a bail hearing I am seeing. Bail will have to take it up first. We are upgrading bail matters, item 31 and 32.
Mr. Lordship. From the office note, it's appears the service report is not completed.
Oh, respond number 2.
Yes, sir.
Okay. As per the High Court rules, now you'll have to send it through the jurisdictional police station to serve it. If this is POXO, you'll have to use your police station to serve it.
Yes, please.
You have to button up your coat first.
Yes, Your Lordship.
Button up your coat has to be buttoned up. We will not hear you.
Sorry, Your Lordship.
Hmm. But the learned counsel for the petitioner as well as the learned APT for the state, respondent number one. Next bill. Office note dated 4/4/2025 discloses that the service report on respondent number two as well as the TCR are not received. Next bill, accordingly, the petitioner shall take first steps for service of notice on respondent number two. The registry on receipt of the notice and a copy of this application shall process the same and hand over the same to the office of the learned public prosecutor, so as to enable the learned public prosecutor to have the notice served on the respondent number two through the jurisdictional police station, that is Itanagar Women PS onward service on the respondent number two. The officer in charge of Itanagar Women Police Station shall ensure that the service report is sent back to the court through the office of the public prosecutor. Next para. Steps to be taken by 8/4/2025. The service report shall be returned back within 21/4/2025. Next, list on 22/4/2025. You take steps, give it to the registry by tomorrow.
Yes.
We'll have to process it and serve it.
My lord, the alleged accused, my lord, he has applied bail.
We have not taken steps.
We have taken this, my lord, even they are appearing, my lord.
I don't know about how it is processed. The office note says not processed.
Yes.
Then how did you appear?
I just been instructed by the victim of the father here. And I've received the petition copy also.
It's doubtful.
My lord, in fact, the victim, my lord.
No, you see, if you see, there are two things. Number one, how would the father of the victim girl know about the bail application being filed when you have not taken steps? So somebody appearing, you have filed a Wakaratnaman.
Yes, yes.
But we will not accept your appearance.
My lord, the victim and the alleged accused, my lord, they are relative, my lord. That is why, my lord.
It doesn't permit the court to accept the appearance of the respondent.
That is true, my lord. That
If
is
you
true.
don't take steps, we can't accept the appearance by somebody. Just
We have taken a step. We don't know, but whether.
I don't know. If this is there, you tell us.
Kind of indiscipline.
But we are sorry, we can't accept your appearance. It has to be served. We are doubting the bona fide of your appearance without service of notice.
Okay.
My lord, in that case, we will have,
We'll fix a date for appearance because we can't take cognizance of appearance without, because we can't verify. Who is appearing before us, we can't
in
verify.
fact, my lord, after the filing of this, the bail application, my lord, they are in talking terms and even they are trying to,
See,
my
that's-
lord, settle
you
the
should-
matter outside the court, my lord. That is why, my lord.
That's okay. You should have told the court.
Yes,
We are in talking terms, I will bring.
Yes, sir.
Then the court would have not passed an order to take steps. We are doubting the bona fides of appearance. Without notice being served, if you are, they are made to appear. Where is the Vakalatnama you have filed? Your Vakalatnama is also not on record. When did you file it? Huh? Before?
Before that,
Before the registry.
before the registry.
You don't, it's not here. Who's signed the Vakalatnama?
The father of the victim guy.
There is the difficulty. There is the difficulty. Look at the cause title. She's a minor, 16 years. There's nobody to represent her in the cause title. You don't say Miss X represented by so and so. You just say daughter of so and so. Minor cannot be compelled to appear. Now, party would be Miss so and so, and appearance by the lawyer is through the Vakalatnama of the father. Because then in the Vakalatnama, he has to say that he's the next friend and then accept it. Whether those things are there, we don't know. But just call for that Vakalatnama. You filed before whom? Just tell the courtmaster. Wait for some time. Let me have this Vakalatnama. Next. वो बीच में आगे रहिए 21. Yes,
I am here for contempt number 7.
Yes.
Actually, upon the learned honorable single bench
Just a
judgment
moment.
obtained already complied for.
Just a moment. Item 24.
34.
नहीं A24 लिखा है. What?
34.
It's not contempt. A24 लिखा है. हो गया कि नहीं हुआ? हो गया कि नहीं हुआ? So this is 24. I'm sorry. Just a moment. Item 24.
20.
This is matter. Yes.
Your Lordship.
Yes.
Lordship, I'm praying for disposal, Your Lordship. Here I'm challenging the impute order appointment of the private respondent
The
number
office
4.
note says that respondent number 4 service report is not complete.
Lordship, may Paris order dated 28/2/2025, Your Lordship. Service upon R4 has been accepted, Your Lordship.
Just a moment. We don't know about that. 28 to 25. Okay. So,
May Your
for
Lordship.
hearing then?
Yes, Your Lordship.
Okay.
Lordship, in this matter, I'm challenging the appointment order of private respondent number 4. The authority.
As
Here, Your Lordship, the petitioner and the private respondent both are serving as contingency staff. Your Lordship may turn to Annexure 10, Your Lordship. DPC annexure 10.
No, we have to fix some other day for hearing. We're just asking you for what post?
To the post of MTS, Your Lordship. From the post of contingency staff.
To the
And-
post of?
To the post of MTS, multitasking staff.
Acha, multitasking staff.
Yes, Your
Okay.
Lordship. The private respondent is junior to the petitioner, Your Lordship, as per the seniority list. And there is an OM, Your Lordship, which says there has to be a common seniority list.
Seniority list of contingency peon.
Yes, Your Lordship. That is in annexure 6, Your Lordship. Page number 2, Your Lordship.
42.
Starts from page number 42. My name is at serial number 47, Your Lordship, page number 44, serial number 47. And the private respondent name is at serial number 48, Your Lordship. And as per the OM, Your Lordship,
Ms. Prasad, you have a copy of your affidavit in opposition by respondent number 2 and 3.
No, Lordship. Respond. Yes, Your Lordship.
2 and 3, please come to page 71,
Lordship.
subparagraph 2A.
2A.
What do you mean by this last 5 lines?
Lordship. Which line?
Page number 71.
Yes.
Paragraph Roman 2, subparagraph A.
Yes.
Last 5 lines. This time,
This time that is on 11/12/2023, ALC staff were considered for promotion to the post of multitasking staff. And in the next time, contingency staffs will be considered for promotion to the post of MTS. Your Lordship.
so this is ALC and this what do you call ALC and contingency staff, they are two separate.
Yes, they are maintaining two separate seniority lists of contingency staff and ALC staff. And the practice they are following is to regularize the contingency staff and ALC staff on the alternative basis. So this time they have considered the regularization of ALC.
Where is the government guidelines for that? Where is the government guidelines for this roster type accommodation?
Actually, Your Lordship, as per the, we have filed affidavit by administrative reform also, and they have clarified that, Your Lordship, there has to be the single combined seniority list and not separate, Your Lordship.
We'll have to file an affidavit to tell us what is happening.
Your Lordship, may kindly see the affidavit filed by respondent number 1, Your Lordship.
Respondent number 1, it doesn't take us anywhere. Affidavit of respondent number 1 says
yes
that we don't maintain the seniority These seniority lists are maintained by the deputy commissioner.
Yes, Your Lordship, but
With that statement, how does respondent number 1 help us?
but in respect of the notification dated 9/1/2012, Your Lordship, that notification they have clarified, Your Lordship.
Where is that?
Page 92 of respondent number 1, Your Lordship, 92, paragraph 2, Your Lordship.
Page 92.
Yes, Your Lordship, paragraph 2. As per the OM dated 9/1/2012, all departments appointing authority should maintain a common list register of serving contingency staff, which invariably should include both the skilled and unskilled serving contingent staff in their department offices in order of their date of joining as such staff. Actually, there should be a combined seniority list, Your Lordship, and not separate.
Okay, we'll take it up on Thursday.
Thursday.
For hearing. Okay. But also as a representative. No, also. The counsel for the petitioner and the state respondents are present. None appears on call for respondent number 4. Next para. This is the matter on Thursday.
Obliged.
Thursday will be
Obliged.
10/4/2025.
Obliged.
Yes. This is a bail matter. See, this is what has happened. We would have foreseen. Yeah, take it. Now you see somebody else has signed this. It is his father. Technically, you see, please tell us if we are wrong. In the cause title, the minor victim is the party, respondent number 2.
Yes.
You have not stated in the cause title that she should be represented by her father. Now, how can the father file a wakala without saying that he is the next friend? And next friend business is only there in the CPC. High Court rules in respect of criminal jurisdiction does not empower a next friend for appearance.
In that case, my lord, I may be allowed to take fresh step then, my lord.
No, just tell us if you are wrong. If my approach is horribly wrong, I must correct myself. I'm just asking you. Because technically the father is a non-party.
Yes. He is not a party here, my lord. That is true, my lord.
But minor. You can rectify it. You take an adjournment today, we permit you to amend the cause title, allowing you to show the father as the next, the minor to be represented by the father. We make the action in the cause title and we issue a fresh notice. You do it by hand, we'll permit you.
Yes, my lord may allow
We'll allow
me
it.
to do it by hand, my lord.
You can't do it here. Under the High Court rules, you'll have to do it before the registry. They'll have to correct the central registry. Before me, you can't do it. Now I'm not the empowered officer. It has to be done, constitutional amendment must be done before the registry. You do it, but we'll allow that.
My lord may kindly allow me to correct it.
We'll
I
do
will
it.
do it, my lord.
Mr. The county clerk counsel for the petitioner is present. APP, you are there as APP.
Yes, Lord.
Your name I forgot.
D. Loy.
Mr.
D. Loy.
D. Loy. Learned. No, Mr. D. Loy, Learned APP is present.
PP, Lordship.
Learned PP is present. I'm sorry. Mr. Nama
And the other
Dudom, D-O-D-O-M.
M.
M, okay, M. Then counsel has entered appearance on behalf of the father of the victim. Father of the victim. And the victim is implemented herein as respondent to by an order dated 19/3/2025, the court had directed the petitioner to take steps for service of notice on respondent to number 2 through the office of the public prosecutor. As per office note dated 4/4/2025, steps for service of notice upon respondent to was not taken. Therefore, as the court notice was not issued on the respondent to, the appearance by the learned counsel on behalf of the father of the victim is not accepted. Mr. Howard, Vakatama is permitted to be detained on record. Next paragraph. On the prayer made by learned counsel for the petitioner, the court permits the learned counsel for the petitioner to make necessary amendment in the cause title in respect of respondent number 2. To insert the following words after the name of the father of the petitioner. Give a dash and then inverted commas. The victim is to be represented by father. The said corrections of the cause title shall be done in the presence of the AOJ, Deputy Registrar Judicial, would enter the said corrections in the central registry. Next paragraph. The learned counsel for the petitioner shall take steps for service of notice on the respondent to the office of the learned public prosecutor by submitting a copy of the written notice and the copy of this bail application. Of the registry, on receipt of the process, shall hand it over to the office of the public prosecutor for onward service on the father of the minor victim through the which police station?
WPS SEPA police station.
Through SEPA, SCPPA, SEPA, Women Police Station. So the officer in charge of SEPA Women Police Station shall ensure that the service report is returned prior to the exit of listing. Next paragraph. Steps to be taken within 8/4/2025. Steps as well correction because we taken by 8/4/2025. Service report is made returnable on 24/4/2025. Missed accordingly.
My lord, can it be on 21st of
The
April?
service
my-
report will be very difficult from SEPA.
It is not-
Physical transmission of the documents will be very, very hard. Because this week will be a few festivals of your communities are also there.
My lord, SEPA is not too far, my lord. It takes hardly 3 hours nowadays, my lord. And more so, my lord, I have some, my lord, difficulty on 24th, my lord. That is why, my lord.
Okay, 22nd, make it 22nd of April. Okay. Okay.
Much appreciated.
Right.
Please, Lordship, my lord, this is tender matter, my lord, though it looks voluminous, my lord. Can it be taken up if Lordship permits tomorrow or day after tomorrow? My lord? Otherwise, this tender matter, the matter would become infectious. Otherwise, it's very, I'll shorten it, my lord, hardly for 15 minutes, my lord.
Okay, then take it tomorrow.
Tomorrow.
That's as a representative. It's a P Tupper and counsel for the petitions, which there is some urgency in the matter. Mr. D. Counter, the standing counsel for the RWD is present. List on 8. 9.
Tomorrow.
9. 4/2025.
Obliged. Appearing on behalf of Senior Counsel Mr. P.K. Tiwari. This is a tender matter. The other side is yet to file their affidavit. Though we are protected by a stay order.
I'm praying some more time, my lord, to file a portion in discussion.
I have been instructed to inform this court this second time, so a short date may be given.
Okay. Mr. A. Sharma and counsel. The petitioner is present. Mr. L. Pamil, and it's standing counsel for the
Power Department.
Power Department. Raise for some more time to file affidavit in opposition in the matter. Yes, you are appealing for?
I for the respondent number 9.
Private.
Okay. Yes, what do you have to say?
In the meantime, we will file a counter affidavit.
The learned counsel appealing for respondent number 9 also placed for some time to file affidavit in opposition in the matter. Next paragraph. Let the matter be listed
On April 25th.
on 25.
24th April also.
25 for 2025. This will be affidavits. Was positively filed by 24 for 2025.
Yes, your Lordship.
Okay.
As a last chance, Lordship. I was instructed because the third time we are taking time. And the stay order may be continued, Lordship.
Okay, stay, interim order passed this and extended to the.
Obliged, Lordship.
Please proceed.
Actually, we have complied this individual. I think I told that respondent number 9 wants to file affidavit. So, yes, sir.
If I may, Your Lordship. Your Lordship, I'm representing respondent number 5 on behalf of OMOD. Oh, respondent number 9, I'm sorry. Your Lordship, today we were supposed to file affidavit in opposition, but
No, affidavit is one part, but
Yeah,
Mr. Yadav says that, Mr. Doloi says that
Yes,
the order is complied with. Petitioner who's there?
Yes, my lord, they have not complied, my lord. In the letter. My lord, direction is to draw an agreement, my lord. For the rent in between the prisoner and army. But that has not been done.
Area rent to be paid within 45 days. You have not got the payment of rent.
There is two parts in the order. One is for the payment of the area rent, and another is to draw an agreement between the prisoner and draw an agreement for the rent.
But that will have to
That
take time.
direction is
Where is the direction? Which part of the, which paragraph of the order is that direction?
Paragraph 8. After the hearing about a party upon the perusal of the material on record, this court is unable to accept the submission made on behalf of the petitioner the direction is liable to be issued for the permanent acquisition of the land. This court is opinion that necessary or otherwise the plot of land can be applied by the recording authority and the reed petitioner does not have any indefeasible right that his land has to be acquired. As regard the rent which has been agreed to be paid, though the rate of the period of February 2015 to December 2020 has already been worked out, this court may not have any scope to interfere. However, so far as the period from the year 2020 to 21 is concerned, the rate may be negotiated by the petitioner with the Army Authority under the aegis of the Deputy Commissioner of Purchasing District or any officer delegated by him. The opposite action has been given that the fair and a reasonable rate has to be arrived. As apparently the petitioner does not have same bargaining power. The reed petition is.
So for this, there is no time limit.
Oh.
For this part, paragraph 9, there is no time limit. See paragraph 9, the dispose of the reed petition with to pay the rent as per willingness certificate within 45 days. That is complied with. The first part of the order to have an agreement.
Yes.
There is no contempt made out because this will be insofar as the territorial army is concerned, they have to do it in the name of the president. It doesn't happen in 45 days. Rent will be proposed by the deputy commissioner. That's why court did not give a time.
But just your lordship will 30 seconds only. My affidavit in opposition to his lordship is the last page. I'll be respondent number 7. Last page.
Respondent number 7.
Yes. Last page and extra H. Payment of hearing charge
No,
for
this
rent.
is affidavit by
It's my lord, 7 my lord.
respondent number 7. Yes, got it.
Last page, one, next H.
Yes,
So
make sure it's-
rent is paid up to 31st March 2023.
But what happens to that agreement? How you are making that happen?
Agreement actually of the rate should have been approached for this agreement. They should have been approached for the agreement.
That is why, my lord, respondent number 9 is the affidavit of respondent number is required. Because here,
Very well,
contract is
please
given
repeat
to the deputy commissioner. And I think deputy commissioner has called the army authority, but army authority is failed to appear. So there, respondent number 9 affidavit is required.
If I may, Your Lordship. Your Lordship, I'm for the respondent number 9. We have complied the order, but we could not submit our affidavit as of now, since we are having difficulty
What
contacting
what
the
compliance did you make if Mr. Dolo is making the payment? What compliance have you made? The payment is made by Mr. Doloi. What compliance have you made?
My lord, this for the direction, my lord, they have been called, but they have failed to appear. And my lord, this order is actually backed by the provision under the Land Acquisition Act. In Land Acquisition, under the Land Acquisition Act, there is a provision for the hiring. That
Under the Land Acquisition Act is different, rent agreement is different. The rent agreement does not come within the ambit of Land Acquisition Act.
Section 81, my lord, section 81. In section 81 and 82 cover this direction, my lord.
We don't talk
You have
like
read- You have read section 81.
81.
You have read section 81.
Temporary occupation of the waste or arable land procedure when the difference as to the compensation exists. Whenever it's appeared for government that the temporary occupation and use of any waste or arable land are need for any public purpose, the appropriate government may direct the collector to.
In this section 81, to cut it short, in section 81, rent agreement is not envisaged. It is a mere compensation for occupation for 3 years. Rent agreement is not covered by section 81. Don't worry, when I have free time, I read these things only. It's a compensation for occupation of the land.
They can have the land for 3 years. That means that is the amount to the rent, my lord. Acquisition is permanent acquisition, but this is the temporary.
Please understand the question. Under this right to fair compensation and transparency in land acquisition, where do you find the provision for rent? This is a act for compensation for the land acquired. So if it's a land which is temporarily occupied with waste or arable, then you get a compensation. Look at the first line, it is compensation. Rent is never a compensation. Compensation is something which is equivalent to rent, but for illegal occupation. Correct. So when we pass decrees for eviction of a unauthorized tenant, we say that the landlord will get a compensation and equivalent to a rent for so and so.
I thought since it's for the temporary occupation for 3 years, it's amount to the rent.
In act, every word is necessary. And we can't import the, you see, for a rent agreement, what are the essential conditions?
There should be a term and conditions.
There should be an agreement.
Yes.
In this occupation of land, was there any agreement? No.
No agreement. That's
Therefore, the agreement must be made and not under section 81. Misapplied. Who is number 9?
Deputy, it is DC.
What is your compliance? You have no compliance at all.
No, Your Lordship, as of now, I was supposed to file affidavit in opposition.
That is, we understand. But in affidavit, you will say what?
Yeah, we have this forwarding letter of calculation sheet of revenue.
Mr. Dole, how much amount you have paid?
Last minute, 8,000 was left out, that was paid.
No, how much amount? Total amount paid?
All total. All total minute, we have given an extra or triple fine.
Just tell us.
Just a page minor. Just minor. Your Lordship may take to page 4, my. Page 4.
Yes.
Of there, and we have paid minor 63,000 6 lakhs 6,39,021 on 18/11/21. Then we have given all extras, my lord. Then subsequent 1,94,808. All rents are paid, my lord. Accordingly, the price has been also enhanced to 10 rupees from 8 rupees.
If there is no scope of agreement, then it will be in the future.
Scope is something else that you'll have to explore by writing to these authorities to make into an agreement.
This land is situated in China border, my lord. It's a very volatile situation. But maybe army may be required, may not be required.
My lord, whole place, there are 3-4 places settled.
These, this instructions, so nothing. Wait, Mr. Dole. Mr. Dole is, you see, what has happened here, from this, we understand that the deputy commissioner has made a calculation.
Yes.
For a certain period up to December 31, 2023. And 89,000, first page, 89,000, right?
Yes, yes, madam.
You say that you have paid more than?
Yeah.
More than that.
Yes, my lord.
And as per your calculation, you have done the payment up to 31st of March.
Yes.
2023.
Yes, my lord.
So from March to December is the only calculation he has made that you will have to bifurcate and find out.
Up to 31st December 2020.
Deputy Commissioner has done nothing. He just took a pen and then a calculator and then calculated, for which he is facing a contempt. That could have been done by anybody in 10 minutes. Making that calculation is the calculation you have made. Mr. Dole has paid more than that.
On behalf of 3, 4, and 5, we have filed our affidavit in opposition. We have stated the details of the payment in page number 40.
Just tell us what is there.
Same, my lord.
Same,
This
my
is
lord.
DO.
DO.
The money goes to DO, then DO
Yes,
gives to deputy
yes.
commissioner, the commissioner gives the benefit.
So in fact, there is no contempt now. We close this contempt and give you liberty to move the authorities to enter into an
Yes,
agreement.
Sir, sir.
Yes.
There is no time limit given for that.
Some scope may be given for the draw of the agreement.
Pardon me?
Some favorable direction may be given so that we can.
In contempt, I can't do it. I can't do it. And if I do it, you will be the first person to go out and laugh. Correct. In contempt, we can't do it. Either there is a contempt or there is no contempt. We don't have an option. Mr. Your name?
Odugong.
Odugong, also for the petitioner. Also heard.
Anuradha Gayan for 3, 4, and 5.
CGC for respond numbers
3, 4, and 5.
3, 4, and 5.
Yes.
And Mr. Dole, you are for?
I am for 7.
3, 4, and 5. And Mr. Y. Dole, Leonard, counsel for respond number 7.
Yes, sir.
And Mr.
And Hari.
N.
Hari.
Hari, H-A-R-I. Learned counsel appearing for respond number 9. Next one. Willful disobedience of the order dated 14/6/2022 passed by this court in WPC 493 AP of 2019 is alleged in this contempt petition filed under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Courts Act of 1971. Next, the learned counsel for respond number 7 has submitted that the order under contempt constitutes of 2 parts. First being a Which page is that order?
It's 16. Direction. Page 1.
Page number?
116, ma'am.
16. Must be the direction.
Paragraph number 9, page 16.
To the effect that so far as the period for the year 2021 is concerned, no. Where is the first part of an agreement? Where is it? Observation of agreement?
That is page 16, para 9, second.
Page?
Page 16, 16.
16.
Para 9. Second part of para 9.
Two parts. Firstly being direction upon the respondents in WPC 493 of 2019 to make payment of the area rent as per the willingness certificate dated 25/1/2021 within a period of 45 days from the date of the order. So the second part relates to the negotiation for coming to an agreement for future rent, for which there's a direction that the same may be held within 45 days on a date to be fixed by the Deputy Commissioner, Upper Siang District, by informing the stakeholders. It is made clear that, and it was made clear that the rate fixed will have a clause for periodical enhancement in view of the escalation in prices. Post hoc. Next paragraph. From the affidavit in opposition filed by the respondent number 7,
Page 4, my lord.
as well as by respondent number
3, 4, and 5.
3, 4, and 5. It is projected that all aerial payments of rent up to 31/3/2023 has been cleared. Therefore, what remains is the current, is the subsequent rent from 1/4/2023 till the current period. Stop. Therefore, insofar as all respondents except the respondent number 9 is concerned, all the appearing respondents except respondent number 9 is concerned, they have demonstrated that their part of the direction insofar as they are concerned has been complied with. Stop. Next para, however, till date, the deputy, the respondent number 9, who is the deputy commissioner of Apar district, has not filed the affidavit in opposition and is not been able to demonstrate that he had done the needful in terms of directions contained in paragraph 9 of the order, that he had organized a negotiation for the settlement of future rent within a period of 45 days from the date of the order. Full stop. Therefore, comma. Till further orders. Now we exempt the respondent numbers 3, 4, 5, and 7 from the personal appearance on the next date of listing, and they can be represented by the learned counsel through video conferencing on the next date. Your personal appearance is also exempted for these people. Next para. The respondent number 9 unless demonstrated that he has complied with the directions concerned. Is put to notice that as no orders have been passed to exempt his personal appearance, the respondent number 9 shall ensure that an affidavit in opposition is positively filed within 22/4/2025, in which the round number 9 is directed to personally appear before this court at 10:30 a.m. on.
Convenient or not.
We are exempted in order, sir.
No, your
Yeah, we
appearance, you are
exempted.
dismissed.
Good,
You can appear through video conferencing.
Yes, but
Please permit you, both of you to. Now we are fixing a date for personal appearance of
Yes.
the respondent number 9, in case he fails to file his affidavit by 22nd. Personal appearance on 25/4/2025. With all the relevant records. And to show that his part of the direction has been complied with. इसमें लिखें वीडियो कॉन्फ्रेंस ऐड कर दीजिए until next date of listing. Stop. ठीक है बहुत अच्छा था वीडियो कॉन्फ्रेंस. With liberty to the learning counsel for the said respondents to extend the exemption from personal appearance to the on future dates. Then list
If I
of
may-
25/4/2025.
Your Lordship, if I may just. Your Lordship, I was told that respondent number 9, the DCU, the then DCU is now appointed and transferred, appointed as a secretary. In what department that I don't know, but that.
You'll have to show that when this order was passed, you were given 45 days. You were transferred before 45 days or after 45 days. When was he transferred? Give the date of his transfer.
I don't know that.
Correct. So contempt has to be purged. He'll have to demonstrate that when he was there, he received a copy of the order. What did he do? Wherever he is.
Yes, sir.
That will be his responsibility. Next, Jesus adds to the lines. The learned counsel for the respondent number 9 has submitted that he has instructions that the respondent number 9 is no longer the deputy commissioner of which district?
Upper Siang,
Upper Siang district. And who is the new incumbent? Who is the new officer there?
New DC.
New incumbent, accordingly, the learned counsel for the petitioner shall take note that the respondent number 9 is no longer the deputy commissioner of Upper Siang district and take such appropriate steps as he may be so advised. Mr. Okay. Mr. Dorian.
Yes. Actually, what I am informed the current and has been also paid, but
No,
we have not filed it.
But let me ask you.
Yes.
Is the order passed detrimental to your interests?
Yes, yes, right. Actually, what about your occupation of the land? Now we have increased the price also.
The order passed, is it detrimental to your interest?
No, why not?
Must have.
In this matter, the state of Assam was
I have
supposed to.
asked, you said,
Yes.
I have asked because I have as straight as a jalebi.
Wait, please, Your Lordship. Lordship, in this matter, the state of Assam was supposed to file an affidavit. I had informed Mr. D. Gogoi, who was representing my lord. Most probably. Respondents 4 to 9.
State of Assam.
Yes, my lord. This matter was pertaining to a border dispute, my lord, and there was a registration of a case of an FIR, my lord. There was no prosecution sanction.
On the last occasion, Lordship, student person from the forest department, so 2 weeks time to file affidavit. But
Yes.
Yes. I don't know whether you have seen this or not.
Right.
There's a document here, which is a letter by the District Commissioner Sonitpur,
My lord.
dated 19/6/2024. It says that since the incident happened in Halem Revenue District and Borgang Forest Range, Vishwanath, the undivided Sonitpur district, there's no relevant documents with the District Commissioner Vishwanath. How do you deal with this issue?
My lord, the state of Assam, my lord.
State of Assam will be represented by many authorities.
My lord,
Now,
because
look at this and
yes,
think of us.
because ultimately the prosecution sanction has to be given by the state government, my lord. Since I was a ACS officer at that point of time.
No, we don't examine the
My lord,
records. We're just showing you this letter which
Yes,
is there on record. Have
Oh.
has your attention been drawn on that or?
My lord, this one, they should not have written a letter directly, my lord. That
No,
is-
but still, since it has come.
My lord. My lord, but the forest department will be having, because it was a forest eviction operation going on.
Who's appearing for the state of Assam?
Well, Mr. D. Gogoi appeared on the last occasion. Time was sought on his behalf. I in fact informed him yesterday, my lord. Mr. Dixit
Gogoi.
Dixit Gogoi, my lord.
He's appearing for the forest.
For the Standing Council Forest, and he informed me that he would appear for the for all the respondents.
It has not come today.
He has not come, my lord. The matter would boil down to, my lord, the granting of prosecution sanction. And I am also told in the meantime, there were some, my lord, discussions in the chief secretary level.
Notice is served on them.
Yes, my lord.
Today, when the matter was called up, Mr. P.D. Nair and counsel for the petitioner, and Mr. D. D. Loy, the public prosecutor is present. For the state is present. Next para. There's no representation from the authorities of the state of Assam. Rate as respondent numbers 4 to 8. Next, the policy reveals that on 11/3/2025, Mr. D. Gogoi and his standing counsel for the Forest Department appeared for the Forest Department of the state of Assam and sought for 2 weeks' time to file objection. So no objection has been filed. Next, madam. The learned counsel for the petitioner. No, you write, stop. For answer justice, we intend, the report intends to put the PCCF from Assam within bracket respondent number 5 and the 5, the deputy commissioner Sonitpur within bracket Sonitpur Tejpur within bracket respondent number 6. Make it district commissioner. Or you'll have to make the correction of the cost title also.
My lord, at that point of time in 23, most probably
But still
it was,
now,
my lord.
district commissioner. And the superintendent of police, Sonitpur, Tejpur within bracket respondent number 7. Notice that if they fail to appear on the next date of listing, the court would presume that the respondent numbers 4 to 8, or not 4 also. In notice to the Chief Secretary to the Government of Assam, they may respond to 4. So, in the event they fail to appear on the next date of listing, the matter would be heard and decided on the basis of materials available on the record. Next paragraph. We permit the learned counsel for the petitioner to send a downloaded copy of this order to the respondent numbers 4, 5, 6, and 7 to their official email address. And the printout of service shall be produced on the next date of listing. Next paragraph, the date of appearance and affidavit by the state of Assam and its authorities being respondent numbers 4 and 8 is fixed on 304 2025. No, not 30 is short time. Make it.
Could it also be, could it be on 14th?
14, you are picking too many cases.
My lord.
We make it 15.
15.
Stay back.
My lord.
15, 5/2025. List down 15, 5/2025. Give them notice, otherwise it doesn't take us anywhere. The service report is not complete. That's the problem. The office note,
Yes, my lord, that service report is.
office note says that the service report is not complete. But he appeared, his Varanasi is not there. And so therefore, for whom he is appearing, we can't take cognizance. And the Cindy Gube appeared. So how is Varanasi is not found on the document? No, not his Varanasi, not his memo appearance is found on record.
There's an interim order, my lord, 17
Interim
day.
order passed. It just stands extended to the next notice. Deeply. This is
Initially, it was moved in the principal seat, my lord.
also just add there. On the fair made by the counsel for the petitioner is permitted to make necessary correction in the cost item in respect of respondent number.
Respondent number 6.
Deputy Governor.
Respondent number 6.
Respondent number 6. Including the district commissioner in lieu of deputy commissioner. Also, the district commissioner. The same shall be done by providing a typed out copy of the cost title to the deputy registrar within bracket judicial, so as to incorporate the same in the this criminal petition. Detailed. This not being adjourned. All this are being adjourned. All these are being adjourned after vacation. I really don't have the energy now to sit.
Your lordship, I fix this on 5th May for the next one.
5th May.
Yes, lordship, I come from outstation, so it will be
okay.
Deeply obvious.
Miss, your name?
Lordship,
Bulia Pulu.
Lordship, I am appearing on behalf of JGNE, Lordship.
Learned counsel
Yes,
to the
your
petitioner.
Lordship, on May, appearing on behalf of JGNE, Your Lordship. On May 5th, he will be preoccupied. He will be there in the Guwahati, Your Lordship. After 12, from 5 to 12, he will be there in the Guwahati. After 12, any date maybe, Your Lordship.
Your lordship, they have been taking adjournments on
It's
every
okay,
occasion.
you leave those days, take any other day.
On
Yes.
2nd, then 2nd May, your lordship.
2nd, okay.
2nd May.
No,
Deeply obliged.
Lordship, from 5 to 12, he will be there at Guwahati. So before 5 to 5, he will be busy in some personal work, Lordship. After 12, he will be free.
We can't have a roster of the advocates like that.
Lordship, he will.
If court is not his priority, then tell us the court is not his priority.
Yes, Lordship.
You can't have a choice that this day I'll do my work, this day I'll attend that, that day I'll attend that court, this day I'll attend that court. And so therefore this court will give you a date or only of your choice.
Lordship, it is on arbitration method there in the Guwahati, so he needed to.
We are not, you see, when you are out of station, we give you liberty.
Yes, yes.
Now you are making a prayer that on that day he has some personal work on 2nd. Yes. Personal work will have to take a back seat.
Not that also they did not appear, your lordship. They have been taking adjourning the matters again, time and again, your lordship. So this is the 3rd time fixed for hearing, your lordship.
You can't have a choice.
2nd May may fix, your lordship.
Can't have a choice like that. And the difficulty in his appearance today, he did not appear today.
Yes, your lordship.
Why?
No, he thought that my matter might not reach.
That's the problem. That is the problem. You think of too many things. We can't allow that.
Lordship possible after
Correct.
12 also.
You see,
Yes.
the answer is very simple. Now, if you're instructing counsel thought that matter would not reach, that means I am a fool. What will you call me then? I don't fit your expectations.
No, it's not that.
Correct.
No.
Then what do you tell me?
My
would-
submission might
my
be
name would
wrong.
only be fool then. That I am the only fool in the court.
No, yeah.
They have an interest in taking up the matters.
That was
We have been watching the court all the entire day. Have you seen in any of the matters I was unprepared?
no, Lord.
Do you think it is impossible for me to reach this item 44 by 12 o'clock, 12:30?
No, your Lord.
If I do it, will it help the bar?
No, Lord.
It will not help the bar.
Yes.
Lawyers with your years of practice will not have courage to stand up and speak before the court. So therefore, I am giving a patient hearing. I am giving you time.
Yes.
I am hearing each and every matter. Correct.
Yes, your Lord.
And don't tell us that the lawyer is so busy that he needs time for himself, needs time for his family, needs time for XYZ.
Deeply sorry for that, Lord.
No. What is happening? The proceeding has been stayed.
Yes, your lordship, stayed.
So what is the issue in this matter?
Your lordship, this IA is regarding the tempering of the order sheets and the notice by the respondents, your lordship, and also by the presiding officer.
It shows that.
Your lordship, please come to page number 7
Page number?
of IA.
Which page number?
Page number 21 and extra 7.
Yes.
Yes. So here you will see lordship that the next date fixes for 16th July 2024, 16th
Yes.
September 2024. So now initially there was an appeal 05/2023 where they were supposed to file a notice to the respondents, but instead of that they filed on 18th July 2024 an order was passed, and 22nd July 2024.
Shows that, otherwise I'll not be able to follow you.
Your lordship.
Shows the pages, otherwise we'll not be able to follow you. You're saying that the order sheet was tampered.
Yes, your
Shows
lordship.
that.
Yes. Your lordship, may please come to page 19 as annexure 5, dated 18 July 2024.
19, yes.
Yes. So here the delay was come down, and then the respondents were directed to issue fresh notice to take steps in regard to appeal number 05/2023, your lordship.
Yes.
So this is very clear order where they had to take the steps. Now, instead of taking these steps, please come to page 21 and extra 7.
Yes.
22 July 2024. They have filed a fresh appeal 03/2024. And the next date was fixed for SR on 16 September 2024, your lordship. And then we had also received a copy of this notice, which is on page.
Just a moment. You see, we can't accept your submissions. Come to page 19. You are referring to page 19.
Yes, Your Lordship.
Please read the order.
Mr. G. Saiki appears for the respondents and has submitted that he represented the respondents in Miss Case number 96, 2023 only. As per procedure, the condemnation petition is registered first and heard. And if the petition is allowed, then the appeal petition is registered and formal notice is issued after hearing the appellant. In the present instance, the appeal petition itself was registered along with the Miss Case number 96, 2023, Your Lordship. Also, there is no instruction for him from the respondents to represent them in the appeal. Therefore, formal notice may now be issued to enable the respondents to engage any counsel of the choice. So Mr. B so-and-so appears for the appellant and he has no objection if fresh notice is issued, Your Lordship. Issue notice states within 7 days, released on 16 September 2024 for SR.
And now this appeal is preferred.
This was actually there was a judgment by the village authority, Gambura, on 17th April 2023, which was in our favor. And then being agreed by that order.
This page 19 order is passed in context of what?
This is in regard to appeal number 05-2023.
What is the order impugned in 5? In appeal number 5 of 23, what is the order?
No, there's no any, 18 July, there's no impugn, this is not an impugn order. Because this.
You're not getting me. Civil appeal number 5.
Yes, Your Lordship.
In that appeal, what is the order impugned?
Yeah.
What is the order under challenge?
Hello. On 17/4/2023. Customary
No. First of all, just tell us.
Yes.
Respond to the court query and then tell whatever you want to say.
Yes, ma'am.
The question is at page 19, we have civil appeal 5.
Yes.
In this civil appeal 5, what is the order under challenge?
The judgment passed by customary court.
Where is that judgment?
Judgment is in the IA, my lord. Actually, my lord, this civil revision is preferred against the order of delay condonation. In
Article
preferring that.
is there. Your counsel is showing me page number 19. We have to
Yes.
understand what is 19 about.
19 is the order in appeal passed in civil appeal.
Which is the order which is challenged in civil appeal 5?
For the IA counter reply. It is there in the reply filed by them in the
This is the third time we are asking you. You are not responding. We are adjourning. Both sides are represented on the prayer made by learned counsel for the respondent. The matter is adjourned. List on 2/5/2025. क्या था ये? Okay, that's it.
My extreme apology, Your Lordship, for the wrong submission, Lordship.
This, okay.
Obliged.
None appears on call. Matter is
Your Lordship, item number 45, we're seeking for adjournment. Currently, this matter may be listed after
Just a moment.
due break.
This is item number 45. Yes, we are adjourning it. You are for?
Your Lordship, I'm for petitioner.
Petition, okay.
Also, this matter may be listed after due break.
After the election, okay. Learned counsel for the petitioner is present. Appellant is present. First of all, as due to positive time, matter cannot be taken up today. Just after the ensuing vacation on a date to be fixed by the registry.